seated. Okay, we are going to call 52049, and I'm sorry, it's wrong. Forgive me, I lost my space. 38020. I want to make sure I'm pronouncing the name. Is it Mercier or Mercier?
Yes, ma'am.
Which one?
Mercier.
Mercier, thank you. I knew it was one of them, I just need to know which one. Thank you. And we are aware of the time announcements of both sides, so you may proceed.
Good morning again.
Yes,
May I proceed?
in your 1 hour, I hope someone can begin that. Thank you.
Shall I wait for this? Or should I just?
They're going to kind of chess clock it and time it, and I guess they'll set it, let me know.
Okay.
Thank you.
My name is Beth Stevens. I'm here on behalf of the Commission for Lawyer Discipline. As a preliminary matter, I would object to the request for judicial notice to be taken as to the, I think, 27 different law review articles. This was filed by the respondent early this week, where he requested judicial notice be taken. And I would object on behalf of the Commission because that's not the proper way to use judicial notice under the rules of evidence. The judicial notice is for adjudicative facts, not for arguments about the law.
That objection will give it the weight and how it's worth. Thank you.
This is a compulsory disciplinary case brought pursuant to Section 8 of the Texas Rules of Disciplinary Procedure. Respondent Eugene Mercier was convicted of conspiracy to commit bigotry. As demonstrated by the record, petitioner filed its petition for compulsory discipline on June 22nd of 2006. Petitioner's first amended petition for compulsory discipline was filed on July 11th of 2006. Respondent was then personally served with that petition on August 7th of 2006 with the petition and notice of hearing by a private process server. Proof of service was filed with BODA on August 16th of 2006, and an interlocutory order of suspension was signed by BODA on November 3rd, 2006. Mr. Mercier appealed his criminal conviction, and mandate was issued by the Court of Appeals for the 13th District of Texas on May 3rd, 2013. Petitioner's motion for entry of judgment of disbarment was filed with BODA on June 6th of 2013. Respondent's reply to the motion for entry of judgment was filed with BODA on April 21st, 2014, and there have been 2 additional filings replying or rebutting that response. At this time, petitioner offers the following exhibits. Petitioner's Exhibit A is a certified copy of the mandate issued on May 3rd, 2013 by the Court of Appeals for the 13th Court of Appeals in case number 13-06-00298-CR, styled Eugene Mercier, appellant versus the State of Texas, appellee. I'm going to go ahead and list all of the exhibits and then offer them. I believe there may be some objections. Okay. Petitioner's Exhibit B is a certified copy of the enforcement of judgment after mandate and order to comply with conditions of community supervision entered on June 7th, 2013 in case number CR-3680-01, styled the State of Texas versus Eugene Mercier in the 332nd District Court of Hidalgo County, Texas. Petitioner's Exhibit C is a certified copy of the Order of Community Supervision after appeal entered on June 7th of 2013 in case number CR-3680-1-F, styled the State of Texas versus Eugene Mercier in the 332nd District Court of Hidalgo County, Texas. Petitioner's Exhibit D is the original certificate from Blake A. Hawthorne, Clerk of the Supreme Court of Texas, dated April 8th, 2014, which indicates that respondent is licensed but is not currently authorized to practice law in Texas. Finally, Petitioner's Exhibit E is a business records affidavit with respondent Mercier's disciplinary history attached, and that was filed with BODA on July 9th of 2013.
Are there any objections, Mr. Connor, to any of those exhibits?
Yes, there are, ma'am. And I filed them up writing with y'all, and if I can just share what it is. In a filing on April 30th, first page of 25 pages, I styled objections to the judgment of conviction and compulsory discipline, and we object to their admission, which is exhibit number this morning. Letters B and C, the enforcement judgment and the order of community supervision. We object to those because subsequently, on April 17th, one of my filings that I've given to the committee, to board, the trial judge entered an order that had the effect to nullify his prior conviction order. And that's a legal issue, but I think I need to preserve the record right now by saying I object to it coming in because it no longer, their document is no longer a valid document because it's been set aside and nullified by the judge under the statute 42.12, section 20 of the Texas Code of Criminal Procedure. I think that's my objection. I set it up more better in the, but if I can incorporate my written page one words, that'd be great.
Surely, your objections to the admission of exhibits B and C is overruled.
So at this time, I'd offer A, well, you said B and C, so are
So-
A and D also?
No, A and D then, actually A, B, C, and D for purposes of clarification. All four of those exhibits are admitted.
And I left out E, Exhibit E is
Okay.
the disciplinary history.
Right. Exhibit E is also admitted.
May I approach?
You may.
I'd just like to note for the board that there are 12 copies of Exhibit C because that was not one of the previously filed documents. The rest were previously filed. And at this time, petitioner respectfully requests that the board disbar Mercier.
Thank you. Mr. Connors?
Pardon me, can you say one more thing?
Sure.
The commission invokes the vote. We ask that excuse
That's the new.
Just 1 minute. All right, Ms. Stevens has invoked the rules, so may I ask, oh, you've already asked him to leave, so.
The witness is
Okay,
leaving, Your Honor.
that's fine, great, thanks. You may proceed when you're ready.
Thank you. As far as my written request to the board to take judicial notice of certain law review articles from across the country, I placed them on my son actually placed them on a CD, and we filed, I think, 12 of these with the clerk, and opposing counsel has one.
Thank you.
Mr. Connor, can you tell me in 10
Reader-
seconds or less what
Reader's Digest version?
Yeah, what is the purpose of providing us with all of these law review articles? What help will it be
I think
to
it'll
us?
make you a lot smarter for all your work at BODA, and hopefully it'll help you in this case.
Well, tell me how it'll help me in this case.
I don't have a succinct answer for you.
Okay, thank you.
Noting the procedural history that counsel listed, and the smallest thing she left out was that when the BODA entered its order on November 3 of 2006, suspending Mr. Mercier during the period of time that he was going to be on appeal on his criminal case, that order was appealed to the Supreme Court. That order had it in a provision in it that whenever he lost his appeal, if he did lose his appeal, he would be, it sounded like, automatically suspended. No more hearings. The Supreme Court granted this today and said that BODA couldn't do that back in 06. He's entitled to hearing at this point. Today, a lot of what we have, and you've seen it in the affidavits, is trying to explain to you. I know there's a theft case back in the early 90s in Nueces County. Interesting about that is St. Paul Insurance Company somehow got two of Mr. Mercier's employees working for them, and they were walking out of his office with his files, not copies, but his files. And then they ended up over at the DA's office, and Mr. Mercier found himself in a position where he couldn't defend himself because I don't have my files. And so he entered into, with the district attorney's office, a theft deferred adjudication case. And then BOTA came along and said it's suspension order, or a court did back then. But subsequently, and one of the filings I have with you this morning is Mr. Mercier's affidavit about that, dated April 30th of this year, that subsequently he filed a lawsuit against St. Paul for failing to give proper information to the investigators and to the district attorney's office about that theft case, and he recovered a bunch of money from that from St. Paul. So if you defraud the DA into getting a conviction, and then, yes, it's a conviction, BOTA can use it, but Mr. Mercier comes along and gets a lot of money from St. Paul because they did defraud the DA. So that's in his record, but we're, I guess, trying to mitigate it to some degree because he couldn't defend himself at that time. And
It wasn't a conviction, it was deferred, right?
Yes, sir.
Okay.
And it all started when there's about 5 businesses on the office complex that he was in got hit by some burglars, and they stole a lot of electronic equipment in the early 90s. Your computers just go out the door with the criminals. And later on, one of his employees said, no, I saw Mr. Mercier putting them in the car. That's his third statement. The first two, in other words, Mercier stole his own computers. The first 2 statements are just the opposite. You know, it was a legitimate burglary. We weren't involved. Anybody in this office wasn't involved in the thing. So St. Paul got 3 versions, only gave the one they liked the best over to the district attorney, which ended up getting Mr. Mercier his problem that ultimately with the bar also.
Notwithstanding that it was deferred, did he plead guilty to a criminal offense back then? Is that what occurred?
That's what we're talking about. It's either guilty or nolo. You can do it guilty or nolo. I don't know the exact way he did it in 90.
But either way, he made some plea.
Right. And then judge always says there's enough evidence to find you guilty, but I'm not going to find you guilty yet. I'm going to give you your probation. That occurred, yes, sir, under our statutes, 4212, Section 5, I think, at the time. Officially, we're under Part 8 of the rules, and it's a compulsory disciplinary action. And so, therefore, the petitioner has to come in here with proof of the underlying felony conviction for us to be still in Part 8. And it's our contention that because of the clemency order entered by the convicting judge in the 332nd District Court that Mr. Mercier has been dealing with since 2000, the year 2000, that has some effect on your abilities to work today. We don't have a case on that anywhere in Texas. The best I could do was under the BOTA system. The best we could do is 1894, long before BOTA, but it's a case of Scott. And Mr. Scott had been convicted of a criminal case. He got a pardon from the governor, and then the state bar, I think it's the attorney general back then, moved in the local county to try and disbar him in the local district court. And the district court disbarred him. And then when it went up on appeal, that's, if I remember historically right, we got our courts of appeals in about 1890. The Court of Appeals thought it has no jurisdiction. It went to Supreme Court, and it came back, and they said, you have jurisdiction, now rule on the merits of the issue. And we've got that case here in our paperwork for you, or parts of it. And it says that without the judgment of convictions still in existence, we can't take this guy's license away.
Right. But isn't a pardon quite different from what happened here? I mean, there's no court that said this never happened and there's never, anything goes away.
A pardon has 2 parts to it. I'm pardoning you and I'm exonerating you of your crime also. There's those kind of pardons. And the other is, like we see the president every now and then for his lawyers, I'm pardoning you so you don't have to go to prison, but I'm not setting aside the conviction.
Right.
So, and we have a clemency that sets aside the conviction, doesn't talk at all. Our statute doesn't allow Judge Ramirez to talk at all about Mr. Mercier is not guilty of the crime at all. But where that puts us is once you lose the judgment, we shouldn't be in compulsory discipline. We should be back at the grievance committee where the state bar has to put on all the acts. They don't have a judgment anymore. They have to prove the acts of misconduct. And so that's why BOTA has, under our thoughts, this Scott case deprives you of the jurisdiction. The petitioner goes to California and cites some doctor cases, and so I got upset with California law controlling here at Boda, so I went and found me a California case that cites Scott, our Texas case from 1894, and says that's what we do here in California for lawyers also. I think that's a 1915 case, which I called to you in my latest filings this week. But the commission thinks that the way we disbar doctors and police officers and DPS decides who can have a handgun and can't have a handgun, and that's been litigated at our Supreme Court in this room here, that all applies to attorneys and what you folks should do here to Mr. Mercier. And it seems to me that there's a statute on who's eligible to be a doctor. There's a statute on who's eligible to be a police officer. And like in my county, if the sheriff pleads guilty, he can't be a police officer anymore, and his son. And the Panama Union employees, they can't be cops anymore. But why? It's because we have a statute from our legislature that sits across the hall in another building nearby, and they set up the rules.
Would you agree that the legislature gets to set the rules for police officers, for concealed carry permits, for even the licensing of doctors, but that the Supreme Court has inherent authority over the regulation of the legal profession?
Well said, and I so agree. But the legislature has passed a law that aids the court, and the court accepts that legislation, and then we come with our rules for professional conduct, which didn't come from the legislature. They came from the bar. And
would you address the appellee's argument that, or the petitioner's argument, excuse me, that the legislature cannot trump the jurisdiction of the Texas Supreme Court to regulate the legal profession by passing 4212 Section 20?
Start with, the governor has clemency powers inside our Constitution. And there was a fight back in 1913 when we first got our probation law. It was held unconstitutional. You can't give probation in a case because everybody has to go to prison. And so about within 2 years, there's another case where the Court of Criminal Appeals accepted that statute, did it right from the legislature, and yes, you could give probation, even though the clemency power was lodged only in the governor. It seemed in the Constitution. And so early on, way back then, we had a statute like this, which used to be numbered 7, then it was numbered, the clemency statute for judges, it was numbered 7, Article 7 of 4212 of the probation statute, then it was numbered Section 23, and then it was the one we have now, Section 20. But a trial judge is also a judge, and it's a trial judge who gives the clemency. And so does that take the power away from the Supreme Court, and they've, through our rules, allowed you to exercise some of the Supreme Court power? Does a trial judge trump the Supreme Court? He's the judge, just like the big judges that sit in this room here normally. And so, yes, the Supreme Court controls our lawyers, but they pass some authority over to you guys to make rulings, and the legislature passed some authority to the trial judges, which, as I understand it, has never been litigated, that trial judges don't have such authority, and it's unconstitutional for the trial judge to give clemency. I've never seen a case like that, and I did a lot of work on this recently.
Wouldn't that turn on the extent to which the trial judge can affect the judgment itself? In other words, I think the petitioner has taken the position, or at least I read between the lines of the position, that the legislature might have the authority to under 4212, to allow a trial judge to ameliorate certain portions of a judgment, such as perhaps the fact that one convicted of a felony cannot vote, that voting right might be restored by the trial judge under the statute. But distinguish that, if you would, from the situation where the Supreme Court always has the inherent power to regulate the profession, so that the Supreme Court, or through it, this body, might have the power to suspend or disbar a lawyer notwithstanding some action under 4212?
That's very close to, I'll answer it this way, very close to the case litigated at the Supreme Court by the board after Boda had suspended the lawyer. And that's called AMENT, A-M-E-N-T, and we find it at 890 Southwestern 2nd 39, Supreme Court. And that was a deferred adjudication case, and he went into court. And apparently his deferred adjudication lasted for this many minutes, 5. And the commission wasn't very happy with that, and they said that's not proper punishment. And so they came to Boda back then, and I know you weren't on there, but they came to Boda, and Boda agreed with them, and we're going to suspend that lawyer. And so then that went to the Supreme Court, and the question became, can the trial judge get in our business, and your business, and their business, and the big Supreme Court's business, and set aside that deferred adjudication 5 minutes after he granted it, and the Supreme Court said, yes, he can. So that's my attempt to try and answer your very serious question.
Thank you.
Did the commission have notice of the April 17th? If that was the day of the hearing of clemency, I know that's an order date. Did they have notice of that?
Ahead of time, no, sir. They received notice afterward. They got us the same day. They got a certified copy of to your people over here.
Did they have notice of that proceeding?
That it was going to occur? No. Judge set a hearing on the 11th, I think it was, of April, and set it up for the 17th. But no, I did not notify Boda, because they're not in my criminal case back home. It's the district attorney's office I have to serve, and they were served, and their prosecutor came to my court. Kyle Webb. In the same line as the state has the handgun case of Tune, T-U-N-E, and they're saying that a person who got his Section 2042-12 clemency should be allowed to have a gun, and Mr. Tune made that argument, and he lost that argument at the court. And that particular statute, I have trouble telling you what cases say. I'd rather just quote you what those judges say, so my stuff is always long. I'm sorry, but so I'm not interpreting missing stuff. You get to read what the judges said in the Tune case from the Supreme Court, and they set out for us what that definition of conviction was. And it included the following: a person is convicted if he was pardoned for the offense unless the pardon is expressly granted for subsequent proof of innocence. That's the handgun statute from our legislature. We don't have that in the Boda rules and the rules of misconduct, in our professional procedure rules. We don't have that in the statute of the lawyer statute. You can disbar a lawyer if he's pardoned or not. We don't have the word pardon in any of those rules. So it's a case of first impression in that sense. Sorry to bring that problem to you, but 1894, we know what the rule was then, and we always have that construction thing. Once a court makes a ruling, the legislature magically knows what that court said, and if they don't like it, they have the right to change it. And since 1894, the legislature have never gotten into the lawyer disbarment business and stuck in the word anything about pardon like the Tune handgun case has. So does that teach us something? I'm going to find out real soon. On April 9 of this year, the Court of Criminal Appeals right across the hall, I got it in a footnote for you. I should have brought it, but it's very long. I may be wrong, but I thought it was 59 pages coming off the court's website. And it was a person who got one of these Section 20 clemencies deals, and now I think it's a person that wanted to be on a jury. But anyway, there's a majority opinion and a long, long dissenting opinion, and in the dissenting opinion, they point out and go through numerous statutes of Texas of where even though you got your clemency from a trial judge in your criminal case after, we call it regular probation, a conviction and probation versus a deferred situation where you're never convicted. They got YAZDCHI. The dissent was pretty upset and listed numerous disabilities that a person like Mr. Mercier, who just got a clemency thing from a trial judge, can't do the following by legislative statute. And it just goes on and on and on. Nowhere in there is anything about pardons and lawyers. But so that's the most recent from across the alley here. the Court of Criminal Appeals in that case on April 9th. And I asked you to look at it. I footnoted it, footnote 3 on page 7 of my filing, I think my first filing that I sent to you on the 21st of April. We have some information about what has occurred to Mr. Mercier since 2006, and he was suspended. We have obviously some before, and that's what the rest of my evidence will consist of. Whether we call it mitigation, we're not saying he didn't do the bribery case, he didn't do the theft case, but here's the man, Mr. Mercier, the human being. Any questions?
Should I address,
Let's see,
at this point, should I address the legal arguments as to why BODA can act, or would you like me to?
I'd prefer you wait till the end, please. Let's go ahead and get the evidence on.
Okay.
If I may, like counsel did, she offered a lot of evidence, I need to do the same. Files that I haven't officially put it on the record, I'm offering all these different things.
Do we have I have a question. Do we have a copy of the clemency order itself?
Yes, ma'am. I faxed that in on the 17th to you, and then I was asked to put it more formal, so that following Monday I sent it to you again.
Okay.
And that's one of the things I want to.
Let me see if you have a copy, Chris.
On the 21st, I filed with your staff the response of Mr. Mercier. There's a footer at the bottom dated this year, 04/21. And attached to that is the very first page of the attachments after my signature, respectfully submitted signature, is the order of Judge Ramirez that you were just asking of, Ms. Chairperson. It's 3 pages long.
Okay, thank you.
We have it.
We all put that into evidence. We'll call that our first exhibit. Then right after that, we have an order setting the hearing in that court signed by Judge Ramirez. We'd offer that as our second exhibit.
I need, if you can slow down a little bit.
Yes, ma'am.
So, Respondent's Exhibit 1 is
the order of clemency.
order of clemency, okay.
No. Okay. I'll be glad to start with my next number. All right, thank you, ma'am. So the clemency order would be Respondents 2, so we'll keep straight. That's a 4-page document. Next one, Respondents 3, is a 1-page document, order setting hearing. And then at the bottom it says copies to Joe Connors and my fax number and the prosecutor's fax number, his name. The next one, which would be number 4, is the motion to reduce and early terminate period of community supervision and to grant clemency, filed April 11th in the trial court, 332nd District Court's clerk. That's 11 pages long.
We have a copy of clemency.
Yeah, yes, we do, and we have an extra one David's looking at, but it is in, he submitted it.
Have we gotten it before?
I think we did. Not
That's what we asked him, and he said it was sent on the 17th.
21st. Next exhibit would be 5, and that's an affidavit from Mr. Larry Daniel. It's dated April 9 of 2014. Next exhibit, I believe I'm up to number 6, would be an affidavit from Larry Laurent, L-A-U-R-E-N-T, dated April 1, 2014. Next would be an affidavit dated April 3, 2014 from, this is number 7, Diana, can't pronounce her middle name, A-R-A-U-J-O Garcia. Exhibit number 8 is an affidavit from John Bonine, B-O-N-I-N-E, dated April 2, 2014. Next exhibit number is? That's an affidavit from Paul A. Smith, number 9, 2 pages, dated April 3, 2014. Number 10 is dated John S. Flint, F-L-I-N-T, affidavit dated April 10, 2014. Affidavit, exhibit number 11 is an affidavit of Eugene X. Mercier. It's 2 pages, and it's signed on the 4th of April, 2014. So all those were given to the trial judge in the original motion seeking the early termination and the clemency. Subsequent to that, Judge was told that Mr. Mercier had paid his fine, and that's what the next 2 pages are. I'd offer into evidence from the Hidalgo County records of their computer, the receipt paying the last of the fine. That would be Exhibit 12, 1 page on that day paying. The receipts dated April 17 of 2014. Next is what we call ABLE term, the local criminal cases system, software system that the courthouse uses in Hidalgo County, and that's a printout. This would be exhibit number 13, I think. Eugene Mercier's case, the case number that you're dealing with, 3680-01-F for the 332nd, that he's paid his fines and his court costs.
I'm sorry, I didn't hear the last part.
That he's paid his fines and his court costs.
Okay.
And that's, I think, a 2-page document. Then I have written down in my handwriting the word BODA only. These are the items that Judge Ramirez didn't get, but I'm filing with you back then and offering him now. April 16, 2014 affidavit of Catarina, C-A-T-A-R-I-N-O, Galvan, G-A-L-V-I-N. Can I impose what number I'm up to?
14.
14. That one is. Another affidavit of Diana Garcia dated April 15, 2014. That would be number 15. Mr. Larry Laurent, number 16, affidavit signed in front of the notary on the 14th of April, 2014. The next exhibit is a judgment that would be number 16? 17. A judgment from the court in Nueces County District Court, 319 Judicial District Court, styled the Commission for Law and Lawyer Discipline against Eugene X. Mercier. That's 2 pages. And then we have the underlying Fourth Amendment, this would be exhibit 18, Fourth Amendment original disciplinary petition in that district court in case number 08-1793-G as in good, filed September 30, 2013. Then on April 28th, I filed with your staff a document called Request to Take Judicial Notice. That's 3 pages long with my signature, and thereafter, and that would, let me just keep going, that would be exhibit number 19, I believe, right? The request for judicial notice. Exhibit number 20 would be the verified style at the top. State of Texas County of Travis, and then it says verified denials, an affidavit of Eugene X. Mercier, and that's dated April 28th, 2014. And if I can step out of the side, why do we need that? If you look at Rule 805 of the procedure rules, it talks about the petitioner's final judgment of conviction or deferred adjudication is conclusive evidence of that conviction, and I guess we can't go behind it as the intent. And then there's a sentence right after that that says if the respondent contests the finality of that order that the other side saying is final, then get yourself in within 10 days of, and this is my problem, of the state filing, the petitioner filing the motion for entry of disbarment, and that was done in June of 2013. So obviously I'm not 10 days after June of 2013, but I'm on the very day, well, this date of filing this affidavit saying her judgment of conviction is no longer good. We did that within 10 days. Sunday's the 10th day, so Monday's falls over, becomes the first day we could do it with your staff. That's our denial that her judgment is no good anymore under our rules of 8.05 that we all have to live with. So that's why this affidavit that we're just mentioning is here. And trying to comply with the rules as best we could, because clemency came down on April 17th. Within 10 days, we're filing this with you. I'm sorry, the next exhibit number?
Will be 21.
there we have, these are the two that I filed this morning. An affidavit of Mr. Mercier. This will be number 21, I think. Mr. Mercier's affidavit dated April 30th, and he's talking to you about that St. Paul and he's losing his computers and that criminal case that St. Paul was behind. And attached to that, we have the order of dismissal of that particular lawsuit in the District Court of Nueces County in cause number 92-1656-F, and the pleadings in that case with Mr. Mercier through his lawyers bringing causes of actions against St. Paul for their conduct that led to him his conviction, his deferred adjudication case of that theft we mentioned. The last one I want to offer into evidence, let's see, I guess I better offer as a separate exhibit 22, the order granting the dismissal of the lawsuit signed by the district judge, and then 23 would be the plaintiff's original petition in that lawsuit we just mentioned, Mr. Mercier against St. Paul Insurance Company and some other people. Now we're at exhibit number 24, I believe. We did the affidavit of Mr. Eugene X. Mercier. And that's dated April 30, 2014. And that deals with sort of his office back in the 90s. And that in 12 years there, he opened about 2,000 cases a year for a total of 25,000 cases he was handling. Attached to that, my next exhibit number is what, 24?
25.
5. That's the judgment from Judge Saki, S-A-K-I-E, a presiding district judge in Nueces County in case number 08-1793G. And also attached to that is I think I've already made an exhibit earlier, but the Fourth Amendment original disciplinary petition that the bar brought against him and filed that on April 30th, 2013. And I'll make that petition exhibit number 26. Okay, so I offer into evidence all those 26 items.
What was number 26? I'm sorry, I thought the last one you referred to was 25, which was the judgment from Nueces
Judge's
County.
order in Nueces County.
All right.
Judgment, the Commission for Law Enforcement has denied all relief they sought in that case after a jury trial. Okay. And what were the pleadings, live pleadings that were on, that they fought that lawsuit about? And that's the next exhibit that we just mentioned. Fourth Amendment original disciplinary petition brought against Mr. Mercier since his suspension in 06 about conduct before the suspension in 06, and then Mr. Mercier was won that lawsuit, and the bar did not get anything from him as far as discipline, although they tried well.
So you're offering exhibits 1 through 26?
At this time, yes, ma'am.
Ms. Stevens?
May I have just a moment to?
Absolutely.
Thank you. May I stand here?
Yes, please. As long as we can hear you and as long as it's picking up on the video, yeah.
Okay. Petitioner does not object to Respondent's Exhibits 2, 3, and 4. As for all of the affidavits, I think it covers 4 through...
Wait, 5.
4 through 10.
No, it would be 5. Because you just said 2, 3, and 4 were okay.
Pardon, thank
Okay.
you. 5 through 10. And then there are 3 other affidavits, 14, 15, and 16. It's my understanding that Respondent intends to call those people as witnesses. So at this time, we object to the affidavits as hearsay, but should those witnesses come testify, we might reconsider on those. I have additional objections about those affidavits if you'd like me to go into those.
If you want to, because I'm going to rule one way or the other. Yeah.
The commission will stipulate that there was a proceeding brought against Mr. Mercier that was tried to a jury in 2012, and the jury came back for Respondent on all accounts. We would object to the relevance of that, but we will stipulate that that occurred, and so...
If I can, I'll accept that stipulation.
Okay.
And so Diana Garcia in Exhibit 7, Mr. Flint in Exhibit 10, Ms. Garcia again in Exhibit 15. They all discuss and mention the Commission's case against Mr. Mercier, and so we object to the relevance of that discussion.
Okay.
And then going to the latter part of the exhibits, exhibit number 21 is Mr. Mercier's affidavit about the theft case and then the ensuing civil case. We would object to that as a collateral attack on the theft case. That's a final judgment, as is the disciplinary case that came after that. That was also an agreed judgment.
Okay. Mr. Connors, are you planning on calling Mr. Mercier with what time you have left?
Just
okay.
And it seemed to me that would be a mitigation of that old suspension, the fact that St. Paul did these bad things. But
I'm going to sustain the objection to number 21 at this time, but I overrule your objections to exhibits 5 through 10 and 14 through 16.
Okay, pardon, I had a few more.
Oh, I'm sorry. Okay.
22 and 23 are the same. They're the order and the petition in the St. Paul case, which is tied into Mr. Mercier in exhibit 21. And so they're the same objections, that they're being used as a collateral attack on his theft case.
I'm going to...
offered for the same reason, so...
Yeah, for the purpose of mitigation, I'm going to overrule your objection.
But you have sustained it as to exhibit 21.
21 is sustained. 22 and 23 are overruled.
Okay. And exhibits 24, 25, and 26 all have to do, 25 and 26 have to do with the Commission's case against Mr. Mercier that went to jury trial in 2012. So we have the same relevance objections.
Okay, I'm going to overrule your objections to 25 and 26. So by my calculations, all exhibits 2 through 26, with the exception of 21, have been admitted.
Here it is, but I don't know what number it is. Oh, somebody just wanted to.
Yes,
A question to Mr. Connors, just not arguing, but just a fact. Are you staying with what you said in your April 30th filing, that you're requesting the relief today of suspension through June of 15?
Short answer is yes.
we
Okay.
like short answers.
And then one other question at the moment. I thought I heard you say, why not, since the order came down on the 17th, that you thought the Commission could still go back and prove the underlying acts? Is that an option?
Well, that's an option, and then Mr. Mercier's bright grievance committee lawyer will say statute of limitations, so they probably lose it if anybody would believe the statute of limitations applies to that conduct. When I raised that in the criminal case, the trial judge overruled me, and all the appellate court says he was wrong, but it was harmless error. We can still try a guy after the legislature pardons him and gives him a grace about the conduct. That's what limitations is all about. Supreme Court's been teaching that over 100 years. So he got a pardon from the legislature prior to the jury trial. We raised it timely. We lost it. We're still here fighting 12 years later.
Thank you.
If I can ask counsel.
Well, may we clarify with the chair, would you like me to respond to the legal arguments that have been made as to why the board can or cannot act, and then have him put on? I thought you said that you wanted him to go ahead with witnesses.
I was really thinking, because you've already proven or submitted the judgment and all that, so I'm really ready to hear, and I'm not trying to tell Mr. Connor how to use his time. It's his to use, but he's, I think, about at 45 minutes of his hour and a half, if not 50. So, and you certainly want time to argue at the end, I would think, so.
Could we ask how much time the record shows he still has remaining?
We'd like to call Mr. Bonan, who's actually here in the building.
All right.
Larry Daniels is a lawyer out in Utah.
Let me ask you, is there an officer there where he is to swear him in?
Wondered if we were going to have that issue. Let me see if we can find somebody to do that.
If not, then we won't accept his testimony, his sworn testimony, but we will allow you to proffer what you believe he would say. And then I might need to, reconsider affidavits or something. So.
Somebody's got to swear him in. Who's going to swear him in? Let me share this with you. Mr. Daniels is an officer of the Supreme Court of Texas. He's a lawyer like we all are. But you still wouldn't want the oath, right?
I think it needs to
No,
be.
that's fine.
I understand sometimes allowing that, but especially being out of state and all, I would feel more comfortable. So if he does not have an officer to swear him, I will allow you to proffer and offer what he would say, or you believe he would.
You'll work on that.
If you will stand up over there and be sworn in by the court reporter, please. You may proceed, Mr. Conn.
Mr. Bonin, you have there with you an affidavit. I've just offered it in evidence. Is everything in there true?
Absolutely.
You signed on April 16, 2014 in front of the notary is one page, right?
Yes, sir.
All right. You signed the information there. Well, state your name for the record.
John Douglas Bonine.
And what type of work do you do to feed your children and your wife?
Today,
Yes, sir.
I'm a sports basketball official. I'm also a art manager and also on a company called Got Wrecked, which Got Wrecked is a company that manages claims and patient care for personal injury.
How long have you known the gentleman seated to my right, Mr. Mercier?
20 years at least.
And the brief version, because we have a time crunch today. You've got some things in your affidavit. We talked yesterday about other things that aren't in your affidavit. You're personally not a chiropractor, are you?
I am not.
Your son is one, right?
Yes, he is.
Looking back at when Mercier did have a law license and you knew him working, what qualities were good about him back then?
With Gene, when I first met him, I had an MRI company. And I need to back up just a little bit because I also know Gene personally. He's been a personal friend of mine for a long time in my family, and he's also been a business friend. The qualities that Gene had that helped me the most was to understand the legal profession. I had an MRI center with a personal injury, and I didn't really understand always stand up. He would always tell me the truth about if I call him about a case or a client that I had, and what was the status of the particular settlement. I always found that if he didn't know the answer, then he got right back to us with the answer. He was always very straightforward with us.
And you've dealt with personal injury lawyers for the plaintiff side, the injured person, a lot in your career, right?
Yes, yes. Many, hundreds.
And you've been to their offices and watched how they do things for their clients.
Absolutely.
And if you can, where does Mr. Mercier stand in all those lawyers you've watched through your career?
I would say he's at the top. One of the things that I've often said is that I didn't have a case while I had his law license, but if I was involved in a auto accident or in my family, he would be the one I would go to for my family and myself to take the case. I mean, that's because he was always, like I said, he was right at the top.
Sometimes we talk about certain people, they follow the rules a lot, and there's other people that I represent in criminal court, that's why they're there. They don't think the rules count. Where does Mr. Mercier fall in that category?
With what I know about Mr. Mercier,
Yes.
the business that I had with Mr. Mercier, we always followed the rules. He always followed the rules. He was, I went to many seminars and training sessions and all these kinds of things that he had, not only in Corpus Christi but down the valley. And it was always a topic. It was always something that was always discussed. We were always, being in the personal injury business and having to go up against insurance companies, of course, that's part of always what you want to make sure of is that you're representing the client and you're representing the client from the provider side as best as you can.
Did you see, in knowing Mr. Mercier over the years and watching him, did you see any fraud or deceptive type conduct?
No, I did not.
And did he have a reputation for being able to quickly settle those car accident cases on behalf of his clients?
Absolutely. We had.
Can you share that with us, what that means?
Sure. What that means is that so much of the time there's different kinds of cases, as we all know. You either have your small impact cases or your large impact cases, and usually the large impact cases are going to take however long they do. But the concerns that providers always had, and we had, was the small claims of property damage in the case is that how soon are we going to get our money and how soon are we going to settle the case? A lot of the times these insurance companies, of course, they want to delay and do whatever they're going to do. But always before, Mr. Mercier would always settle our cases, and we did really big numbers with Mr. Mercier in the Valley and other places because of the providers he was using would send the MRIs to our company. So we were always, as far as the settlements, they were always, let's say for example, we sent the case in and 60 to 90 days later we'd be getting our checks for the most part of our cases, which is really good in this business. It may take up to 6 months to a year with a lot of our other attorneys. So he was always at the top of the list as far as selling cases.
And getting you paid?
Absolutely.
Now, you mentioned the MRI company.
Mm-hmm.
Back when you first met Mr. Mercier, you were doing MRI business a certain way.
Yes.
And then because of suggestions he made, you did it differently, right?
Absolutely.
Can you share that with them
I
and
can.
show how that saved a lot of people a lot of money?
Not only that, it was revolutionary. I'm not an MRI specialist. So in MRI, you have 3 sequences. And it takes approximately an hour and 15 minutes to do an MRI. In the business, those range between $1,200 to $2,000 depending on what companies charge. We were in conversation one day and we were on the road and it came up, it would be nice if we didn't have to do a full MRI that charged $1,500 to $2,000 if in fact it was a normal study. Okay? So we got to talking about it and I called our MRI people and we found out that in the MRI business you could do 2 sequences that would only take 30 minutes and it would show gross pathology. enough to know whether or not you had any impingements with the nerves. And so, obviously, if it was a normal study with the screening, then we didn't have to charge the $1,200 to $2,000. What we could do is we could charge $500 to $600. Then, if there was gross pathology, and we did see that there were some impingements, then you could bring them back in to do the third study. And the third study would then show what kind of impingements they had and what we needed to do. So it really revolutionized the business somewhat, because what my competitors had to do is start getting in line with the prices. Because we could do these screenings, and it not only increased the business that we have, because instead of having an hour and a half that we were having to schedule with each patient, we only had to schedule in 30 to 45 minutes. So it helped the patients, it helped the clients, it helped the industry, it helped everything. So,
And the cost to the client, who then was
Absolutely.
being paid by the insurance company, reduced a lot.
yes, absolutely.
And that revolution was sort of started by comments
Absolutely.
with Mr.
Absolutely,
Mercier.
because what we were talking about is, sorry. Thank you. Okay.
That revolution was started by your conversation with Mr. Mercier.
Absolutely.
All right, now let me take you, that's the past. Let me take you to the future right now.
Sure.
You know Mr. Mercier is helping Mr. Laurent, right?
Oh, absolutely. Yes, sir.
And Mr. Laurent's a lawyer that specializes in helping chiropractic doctors around the state.
Yes, sir, he is.
Do you see Mr. Mercier, if he received his law license back a year from now, June 7th, I think, of 2015, be able to practice law, his license? What do you see Mr. Mercier doing at that time? Can you share with the board?
Well, what my experience has been in the last few years with Gene is that what we've done is with Mr. Laurent is in my new business, which is, managing patient care in the claims industry, whether it be PIP, whether it's third party, whether it's attorney settlements or whatever it is, especially with the third party claims. And what Mr. Mercier and Mr. Laurent has helped us with is the clients that I now have, being able to file these liens has opened up a whole nother industry for us, because we're no longer at the mercy of an insurance company or an attorney. We now have Mr. Laurent, who now has the lien filed on our behalf, to where the negotiations have to come through us. So when the checks go out, then our name is on the check, or the doctor's name is on the check. So it's been a very good thing as far as the whole industry, in my view, because so much of the time, some of the clients that are coming into the clinics no longer have to retain an attorney, no longer have to do things that they had to do before because we had to get a letter of protection. Now we can do these liens, and we can sleep at night knowing that our money's safe. And Mr. Laurent, and especially Gene, Gene has followed these cases. We filed many liens with these insurance companies, because one of the things that's always been a problem with us is that the insurance companies, even though we have an assignment of benefits, they don't have to put our name on the check. So we're out in the open. We're out, even if the attorney, and we've had this happen to us, where the attorney would just pay the client even though there's a letter of protection, and then he says go pay the providers. Sometimes that doesn't happen because the client doesn't pay the provider. Okay? So that's always a dilemma that we have in this business. Okay? So that's what I see. I mean, it's a long version of it, but that's what I see Mr. Mercier and what Mr. Laurent has done for us. And that's what I see Gene as far as the business end of this. Not so much where he's taking in clients, but he's helping manage our clients, to where we can, obtain full payment or at least some payment on clients that we normally might not have.
For the services that you legitimately render?
Yes, sir.
And my question was trying to say we're already in 2015 in July and August, and Gene's now hopefully a lawyer. Can Gene practice law doing that stuff you just mentioned?
Yes.
Like Mr. Laurent does?
Yeah, of course. That's what I'm saying. I mean, I'm sure that's what.
That's fine. Pass the witness.
Mr. Bonine,
Yes, ma'am.
my name's Beth Stevens. It's nice to meet
Yes, ma'am.
you. When you were talking about Mr. Mercier's reputation prior to 2006 of getting cases settled quickly, you weren't talking about you being a client, is that right?
Correct.
And it was beneficial to you as an MRI provider to get paid quickly, right?
Yes, ma'am.
But it might not always be in the best interest of the client to have the money come out quickly. Would you agree with that?
I'm not sure.
Best witness.
call Mr. Galvan and Katarina.
Well, I think we actually get to ask a few questions if
Oh,
we
I'm
want.
sorry.
Does anyone on the board have a question?
Yes, sir.
You made a lot of money.
Yes, sir, my company did.
You know, like you,
Yes, sir. And investment.
and so the period of time that he's been suspended is cost you money.
I'm not in the MRI business anymore.
Well, whatever business you were in, it's cost you money if he can't practice. I don't know what you're in now. I got lost in when all you did, but you don't work with him anymore?
No, sir, not in the area of law.
What area do you work with him in?
What I mean by that is it's very specified now with what we do with Larry Loren and Mr. Mercier in the lien business. Okay, that's what we do now.
I'm sorry, it's very specified what?
With the lien business, sir, where they help us put liens on, like we have a patient come in, sir, and we have a claim. Okay?
So now you're working with him to put liens?
Liens, I'm
Yeah.
sorry, liens, yes, sir.
That he's doing that now?
Mr. Loren is, yes, sir.
Well,
With
what's Mr. Mercier doing?
He's a legal assistant, I think, with Mr. Loren, and he helps follow our cases.
So they, Mr. Mercier in one form or another sends you a lot of business, either with
Oh, that's-
whoever he's now a legal assistant
No, sir,
for?
I'm sorry, it's the opposite, sir. I'm sorry, I didn't make that clear. It's the opposite, sir.
You send him
Yes,
business?
sir, that's correct. With the clients that we have, with the clinics that we represent.
And they then put a lien on it for you?
Yes, sir. On the claim itself.
And you pay him for that?
Yes, sir. We pay Mr. Loren, yes, sir.
But are you familiar at all with Mr. Mercier's past history of his issues with the bar, where he's been reprimanded, suspended, hasn't had his license, not paid his dues, not paid his occupation? Do you know anything about any of that?
Some of it.
How much do you know?
I know the 2006 thing that happened. Yes, sir. Whether he was disbarred or suspended or whatever he was, that's about all I know as far as, the legality of it.
You said he followed the rules?
Yes, sir.
How do you know he followed the rules?
Well, from my knowledge, okay, just from my knowledge.
Which is no knowledge at all. You have no knowledge at all whether he followed the rules.
I just know from the basis of me being a provider, and him being an attorney, okay, and me sending bills to him.
Okay, so he followed your rules when you dealt with him?
Yes, sir.
Okay, you don't know whether or not he followed state bar or Supreme Court rules?
No, sir.
Okay.
Let me just ask one quick question. Back when you were in the MRI business, apparently you said you did a lot of business together. Mr. Mercier had his doctors send his clients to you, is that right?
Yes, sir.
Did you have some sort of formal agreement whereby that would occur?
No, sir. I mean, we have letter of protections once the provider or the
Right.
doctor would send us the MRI.
Do you know if
We would then request a letter of protection, but that's the only document we would have.
Do you know if all of Mr. Mercier's clients who were being sent to you through these treating doctors, do you know if that was all of his clients or just some of his clients?
I don't know.
Do you know if the doctors made independent decisions or they just sent them to you because Mr. Mercier told them to do so?
I believe it was independent decisions that those providers made, but I'm not sure, sir.
Okay, thank you.
I just have a question. Mr. Bonine, you're here to testify for Mr. Mercier. You also said that you, under question, unless I missed it, got it wrong, that he's become a friend of yours. And we are in a mitigation area now to talk about whether his license, whether he'll be disbarred or whether his license might be suspended. And I didn't hear you talk at all about your friendship with him or any of what I call mitigating factors that most people talk about when they talk about, why we should. You talked about business things.
Yes, sir.
You didn't talk to me about, is he a good guy? Does he come to your house? Would you let him around your children? Does he go to church? I didn't hear any of that kind of stuff. Can you tell us anything about that, or are you here just to talk about this business matter?
Oh, no, sir. Over the years, we have spent time together, especially in the MRI days. You know, he would come to my house. We'd go to Corpus Christi. We would have boating excursions. My family was around him a lot.
How about in the last
business.
5 or 6 years?
Last 5 or 6 years, not as much. Just because I'm in San Antonio and have businesses and grandbabies and kids and all that kind of stuff. Really kind of not so much personal this, in the last 5 or 6 years. Mostly phone conversations, those kind of things.
Okay, but I mean, I'm asking you to tell us about him, not.
Okay.
You can tell us anything you want to,
Okay.
that would help him. Whether you had boating excursions, I mean, I expected to hear some more than just this business talk, I suppose, and maybe that's what you were here for.
Any other questions from the board? Does that bring any other questions to mind for either council?
None from the commission.
Okay.
We mentioned yesterday that when your son was little in the July 4th incident or something, maybe that helps what Mr. Taylor was talking about, the person, Mercier, the non-businessman over at your house. Can you share that with us?
Sure. He would come to Kerrville when my sons were, and we would have things like 4th of July celebrations in Kerrville. I don't know if you've ever been to Kerrville. Our 4th of Julys are really big, and he would come over and we would do the event with Gene. And, my family would be around him, and we would, eat barbecue together and do all the things that your friends do. I mean, it was a very personal thing that I had with Gene. I didn't know that was part of what basically I was supposed to, share with y'all today. But Gene has been a really good friend of mine over the years. I mean, I've gone through some very difficult times in my life also, and Gene has been a very good personal friend of mine. Even to the extent of whenever I went through my divorce, he was there for my divorce. He was a good friend and helped me through it all. So it's been a lot of time that I've spent with him. Maybe not in person, but a lot on the phone, talking to him about events in my life that have happened, and that sharing with him and getting his advice on things that I need to do. So it has been a personal relationship with Gene. When he's been up in Austin here, my son went to the University of Texas, and he would take my son out to eat in Austin. He was an active role with my boys. We were down in Laredo together a lot. Obviously, because I had an MRI center there, and he had a law firm there. But my boys were with me a lot, and they were around Gene a lot, and we did a lot of things together in the evenings. I know Gene to be an honorable, decent man. My boys know him to be that way. So he's been a very close personal friend of mine, and he's always been there for me when I've called him and asked him to help me do anything.
According to the records I have, Mr. Mercier has been licensed to practice law since November of 1987. When did you first meet him? Do you recall?
I want to say it was 92, 93. It could have been 94. It was in Corpus Christi at the time. I don't know the exact year, sir. I'm sorry.
And according to the records that I have, by that time he had already had a private reprimand from the state bar, and then around 91 through 94 he was actively suspended. Were you aware of any of that when you first met him?
No, sir, I wasn't.
Okay. Thank you.
Any other questions from the board? Mr. Connors? Of this witness?
No more questions, by me.
Ms. Stevens?
No more questions from the commission.
Thank you. Mr. Bonine, you're excused. May he be excused from the room?
Yes, that's fine.
You
You're free to stay- You're free to stay in the courtroom if you would like.
Oh, thank you.
You can leave it or you can stay.
We're not going to force you to stay, but you may stay. And can we get a time estimate? I'm just concerned for both
The
parties.
next witness is real short.
Okay. No, I was asking Ms. McKeeman so that you know.
Mr. Mercier has 45 minutes and 47,
Okay.
and the commission has 44 minutes and 26 seconds
Is that remaining?
remaining.
Okay, thank you. Just let me know.
You said 45 minutes 20 minutes ago. Thank you.
Well, I thought that 45 minutes for Mr. Mercier was at the start of this witness.
I think that might have
15
been off
minutes.
a bit.
Oh, okay.
I think we've heard 45 twice, and I think we're closer to the,
Right, but he had more time, so he only has, he was into, when I mentioned he started, he had spent 45 minutes. But then we started everything, so now he only has 45 left, right? Or maybe I'm confusing myself.
Oh, he had an hour left.
right,
Had an hour left when this witness started, and he had 45.
right.
Sorry. We're trying.
It's fine.
And Mr. Connor, we'd only ask, Connors, we would ask that you be real sensitive to any kind of cumulative or repetitive type testimony to the best you can. Thank you.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
State your name, please.
Caparino Galvani.
I'll show you. April 16 of this year. Is that your signature on there?
Yes, it is.
I'll offer a copy of that to the board.
Do you remember which exhibit number 16?
Thanks, you can see.
Are you getting there, Chris? In the past, Mr. Mercier, who's seated beside me, has been your lawyer twice, right?
Yes, sir.
And he's been successful in obtaining you money from 2 car accidents, right?
Yes, sir. More so medical help.
And in working with him, you got to know him as a person some, didn't you?
Yes, sir.
Not just the businessman Mercier.
As a friend.
Can you tell these people here in front of us about your friend, Mr. Mercier?
He always seems to have the best outcome for his clients, helps them. Good guy, knows how to find team. And, you know, just a good guy, helps people out. Best he can.
And has he tried to help you with your personal problems, whether they are
Yes, sir.
girlfriend, drinking, whatever it is? Can you share that with the folks?
He's helped me out, like, as far as like, giving me good advice on certain things.
Not just car accidents, but life issues?
Yes, sir.
All right, go ahead.
Such as,
Share with them an example.
just like, for me to go ahead and keep doing what I'm doing with my stage production. I'm a union stagehand, production, entertainment production, IOT. So, you know, just kept pushing me forward, do the right thing, to, you know, get in with these people and work hard.
And how far did you go in high school, college?
I'm a high school dropout.
Dropout, okay. And then who was pushing you to get a job with, so you would have to be able to work?
Oh, Mr. Mercier.
And that's the job you have now, you're a stagehand and inside a union group that works on stages?
Yes, sir. I work everywhere. We're considered professionals, international line, stage theatrical employment. They're IATSE for short, the acronym,
And that requires a lot of climbing and lifting?
climbing, lifting.
It can be dangerous also, right?
Yes, sir. I go up to 400 plus
Feet or yards?
feet.
And when you sort of despair, life's treating me bad and stuff like that, who have you turned to in the past?
Call Mr. Mercier quite often.
And it's helped you?
Oh, indeed.
And you know right now that he's suspended and can't practice law, right?
I've known this for a while.
Right. And we're trying to show these folks that he should get his law license back. So can you help them with any other information than what you've already said? Why he should be a lawyer again in about a year from now? Starting a year from now?
Well, he's helped my family out, you know, he's represented a couple of my mother, my sister,
Pass the witness.
Thank you. Mr. Galvin, my name is Beth Stevens. I represent the Commission for...
Ms. Stevens?
Yes,
I
ma'am.
apologize, but your voice does not carry quite as well as Mr. Connors. Would you mind taking the podium? Thank you.
Is that better?
Yes, thank
Okay.
you.
Mr. Galvin, where do you live?
I live in 1,000 Roof.
In Austin. Okay. And you said that you met Mr. Mercier when you were 19. Is that right? And so what year were you 19? In what year were you 19 years old?
What year was I 19 years old? 1988.
88? So you met him when you first hired him to represent you, is that right?
During a fatality, right?
And do you know about Mr. Mercier's disciplinary history with the State Bar?
I didn't, we kind of lost touch for a little bit. I didn't find out for like 3 years ago.
That he's been suspended? And you know that he's been convicted for conspiracy to commit bear treason?
Apparently that's what you said, that's why he doesn't have his license.
And since you live in Austin and Mr. Mercier lives in Austin, do you all hang out together? Are you that kind of friends?
Sometimes we go on bike rides or we go for swim.
And so you said that you turn to him when your life is in despair. Is that? And so y'all, would you call yourself good friends then?
I would say so.
Okay. Thank you. I'll pass the witness.
No questions.
All right. Does anyone on the board have any questions of Mr. Galvan? Mr. Galvan, you are excused and you are released from the rule, which means you may stay in the courtroom if you desire, but you're also free to go if you want to.
Thank you, ma'am.
Thank you.
Thank all of you.
Knowing our time limitations, I think I should call Mr. Mercier now, and we'll then try and get Larry Daniel, if we can, on Utah.
Okay.
Hopefully he's getting a notary in the meantime. And Paul, I have Paul Smith outside, and we won't have time to call him. Can I get him out of the rule and
Surely.
And let
that's
him come
fine.
in?
Sure.
I'll try and get him to find us a notary in Utah, Joe.
Okay. We have to. I think we'll check.
Jackie not here?
She's here. She's back there.
There she is. I thought we sent them out to get with us.
Can I see the clemency order, George?
The clemency order.
State your name, please.
Eugene X and Mercier.
When you were a little boy, what type of work was your dad in?
He was a physician.
And what'd you learn from your dad? His work ethics, etc.
My father told me when I was first practicing that the people that were the most vulnerable needed the most help. My father was the type of doctor that would do house calls. He had 4 heart attacks. And he kept practicing. He kept persevering. And he taught me that you have to fight for those patients, no matter whether they were hypochondriacs or whether they deserved it, whether they're going to follow his advice or not. The people that needed the help were the people that you had to help most. These are the most vulnerable, the people that needed the doctor, and he taught me that those are the people that need the Lord.
And I think I have at least 4 affidavits that we've offered into evidence today, and your names are on them in front of the notary. Is everything in each of those affidavits true that you signed?
Yes.
Mentioned slightly with Mr. Bonan, you had a big volume back in the 90s, early 2000s. board about the volume of work and why you think you have so many grievances and reprimands in the past.
At the beginning of the 90s, 94, which is about the time I met John Bonine, the rules required you to be in the city where you were practicing 3 days a week. So I would spend 3 days in Corpus Christi, and I wanted to get a law practice started in Laredo. And so I would travel and be in Laredo Wednesday, Thursday, Thursday, Friday, and Saturday. I would meet clients on Saturdays in Laredo. And then the rules changed, and the stipulation was that as long as, for advertising purposes, you state that if you have an attorney, visit with attorneys who are appointment only, and you put the principal office in Corpus Christi, Texas, that you could then open office. So I started advertising heavily in the yellow pages, a lot of back covers, signs and phone books, billboards, Spanish television, Yo también lo puedo ayudar, radio, and internet finally, and really brought in a huge volume of business. And I ended up handling 25,000 cases. And what I was trying to accomplish was just to get lots and lots of clients, the biggest settlements I could, as fast as I could, and just, just keep going and going and going. And that's probably what ended up happening, which was those clients, and having so many of them is what became a problem. Because as soon as a grievance came up, then made me realize, and I realize now, that if I work 750 or 1,000 claims and have 1,000 clients, and then one client gets wrong or feels like they're wrong, then it hurts the public. And I've learned from that lesson. I want to have a chance to practice law again. I know that I won't have that volume of practice. I learned not to do things that way, but I still think that I got good results for most of the people. So I did work the cases for 29%. And by my calculations, I gave back about $2 million to all those clients by reducing their fees. Hardly ever charged for expenses, never charged for postage, never charged for copies. After 1991, I did 3 workers' comp cases. Never submitted a fee for the work I did on workers' comp. I've done Social Security cases since I first got out of law school. I've never submitted for a fee. I've always handled those for free. I've never charged anyone a fee for anything that wasn't a contingency. So I've never sent a bill. I've never had to collect. It's always been from a settlement. And I did a lot of pro bono. I still do a lot of volunteer. But back to the practice, I had a lot of things that I really tried to do, and my focus was the medical. Maybe it was stemming from my dad. I have a boating accident where I had my arm severed, and I have severe nerve damage. I can't use my left hand very much.
Does that give you an ability to, your disability you just mentioned, to sort of work harder for the folks that you're coming in your office with all these problems from car accidents and the resulting emotional and mental problems they have with
Yes.
their...
I had a woman who got run over by a car. She showed me a picture of herself, and I thought she was showing me a picture of someone that she wanted me to sponsor for a beauty contest. And she said that was me. All I could do is take off my roll my shirt up and show this woman my arm. The only time I ever used my disability for my advantage. I never filed anything for it, never recovered, walked away from the potential lawsuit, getting run over by a speedboat. It was clearly someone's fault. Because I decided that I wanted to help people. And I wanted to get the people that couldn't get the medical, I wanted to get them their medical treatment. So the focus of my personal injury practice was make sure that the people got a medical doctor consultation. Don't leave the claimant, don't leave the plaintiff with Cairo only. Because that's a kiss of death in the insurance industry. So we get a screener, just find out if we got a positive finding, save money, get more settlement money in the client's pocket. And it's not something that the panel might appreciate from a personal standpoint, but my job was to get as much money in those clients' pocket as possible. So I was fighting hospitals a lot of times. And if I could get around the lien, if I could reduce the medical lien, if I could bust the lien, if I could get the money for the client and tell them we don't have any obligation to pay that medical provider, then that was my job. And so a lot of people didn't like that, and a lot of people don't like plaintiff lawyers for that. But my duty was to the client. And a lot of times I think I put the client first, the client in front of me, put the client in front of the public. That's probably one of the reasons we're here today, is I would fight for those clients.
If you can help us, Juan Herrera versus Sears, when he was wanting to kill himself after he got hurt, what'd you do?
Juan Herrera called me, and he had a knee injury, and it turned out to be a back injury. He needed an operation from falling in an uncovered manhole at Sears. I handled the case where I ran over to Sears with a tape recorder. I got the foreman to admit, yes, I knew the manhole was uncovered, but I wanted to go to lunch first. And Juan Herrera came and delivered and fell at Sears, so he had a good third-party workers' comp case. And then after that, Juan called me up on a Sunday and said, I'm suicidal. I just can't handle this anymore. So I just instinctively called the videographer and said, I'm sending someone over there to help you, and we did a day in the life. That day in Juan Herrera's life. When we couldn't get the case settled, I referred to Guy Allison. Guy Allison went to trial in Nueces County with me and for me, and got $1.4 million. And all Juan Herrera wanted was a new car. He just wanted a better station wagon, a newer station wagon for his wife. And he didn't know what a lawyer was going to do, but I felt that it was my duty to get the help I needed. I'm not going to say that I was the greatest trial lawyer. I was working a lot of files. I was making a lot of decisions on what was going to have to be done with medical and talking to doctors and conferring and helping people that needed operations and things. So I knew that it was best ethically to refer that case to Guy Allison. And I don't think anyone could have gotten more than Guy. So I know Juan got the best remedy he could possibly get.
One other example of the catastrophic problems of Jessica Garcia with that Ford in Cameron County in the trial of the rollover.
I had a 800 car wreck, and I realize that's extra cheesy, but it brought in business, and I had the back cover of the phone book and the spine and everything in the Rio Grande Valley. One Sunday, Mr. Garcia called, and instead of using an answering service, I had a legal assistant, a live person answering. He heard the facts, and he called me and said, we have a rollover case. And I said, well, what are the facts? And I had never heard facts like this. This was just straight from the TTLA car wreck seminar. It's the best case I'd ever seen or heard of. Not just my best case, it was the best case I'd ever seen. And so I knew right away to get Michael Watts. And Michael Watts tried that case and got what was then the biggest verdict in Cameron County history, $30,400,000 for Jessica Garcia's death. She coma, convulsion death, and excuse me.
I'm sorry.
I turned that down and turned it back up.
Okay, you told us she had a death and Michael got that money for you?
Yeah, she died, and all her father wanted was to stay at her side. The first day, when I found out what kind of case it was, I said, I want to get you a rent car, I want to get you $100, I want to get you to where you can transport your family back and forth. And he didn't even want the $100. He wouldn't take a rent car. He stayed at the hospital, and
Gurewitz pointed out, and some of the other board members, in the past, you have a record commissions, you've agreed to a lot of reprimands and stuff, private, public, suspended for a while. I think it's 7 years, 3 years of that actually suspended, and 4 years on probation prior to getting into this barratry problem. We all want to know, what did you learn from those things? And did you have any type of manual at the office to have this large staff handling these large number of cases to do it right?
I had every grievance that happened became a procedure manual issue. I would have staff meetings every quarter. I would invite all employees in. I had 30 employees, associate attorneys, presidents of the Corpus Christi Claims Association, 2 or 3 of them. I would hire them away from their insurance adjusting jobs. You know, kind of like pro athletes, you know, they get the best and try to recruit them. And I got the best I could to work for me. And they would come up and share what they had learned in the insurance adjusting industry. I would have John Bonan come in, and he had ideas that he had learned to get prescription drugs for the clients faster and more efficiently, and to help them get, you know, the treatment that they needed was prescribed by the doctor. We had forms, and the biggest problem, even though I would send out a letter to each client, and I would schedule in my reading and engagement letter to each client. I'd have a scheduled appointment, and I would meet in person with every single client. I scheduled and made a written invitation and attempt to meet all 25,000 clients, and I think I met 90, 95% of them. And if they didn't show, we'd have a follow-up letter. And I wanted to meet with each and every client. My main reason was I wanted to learn as much as I could about the case and find out if there's going to be prior injuries, subsequent, interruptions in treatment, liability issues, coverage issues. There's always more coverage. I tried to specialize in auto insurance coverage and find more coverage and try to get more of a remedy and more of a recovery for the client by finding additional insurance coverages to cover the loss. But the meetings and the procedures were based on trying to avoid misunderstandings. Most of those grievances were just the clients, and I represented the poor. I represented the poor in my practice. They were the people that were bargain hunting, wanted 29%. That 29% got a lot of people that were already litigious. They were already claimants, past claimants, habitual claimants, professional claimants.
The commission objects to the collateral attack of the prior disciplinary history.
I'm going to overrule that objection. But you might want to be sensitive to time.
And
You tell us about your clients who are poor, poverty-type folks.
And so the 29% would attract these folks, and if they were indigent and they didn't have much of an education, then that was my problem. That wasn't the client's problem. That was just the challenge that I had to take. And by meeting them, I knew which clients were going to need extra persuasion, extra explaining, and we had forms upon forms written in Spanish. We had Spanish translators from the college that would certify that it was a true, accurate transcription and translation, I should say. And even something as simple as a rent car. Whatever amounts that the insurance company won't pay for your rent car is going to come out as a client expense. The contract already says that. We'd have a standalone side agreement. And articles of agreement, side letters of agreement. Clients would write in their own handwriting, I'm agreeing to this. And, it would work most of the time. Some clients would write it and then claim later that they didn't read it when they were writing it. But those were the people that no matter how many times you explained it, it just wasn't possible to explain to some of these people. But that was my job, and that's what I tried to do. And we had procedures, and we had meetings every quarter. o'clock meeting every day from 1987, 3 years off in the early 90s, 94 to 86. Every morning, 8 o'clock meeting, Saturday included.
I think you said 84 to 96, or you meant 96 to 06?
87 to 94, 87 to 90, 94 to 86.
That's where I'm missing you. You're saying 86 at the end. You don't mean 86. You mean 2006.
2006, Joe. Thank you. I'm sorry.
Can you help us with the St. Paul thing?
I'm not listening to what I'm saying. Excuse me.
The St. Paul thing, slow down. The St. Paul thing, I said a lot of things to the board about St. Paul. Was I accurate?
Yes.
All right. Can you add some more details without being repetitious of what I said to St. Paul? I realize you took a theft conviction on it. You took a reprimand from the bar, and you were 7 years suspended, 4 of which was probated, 3 of which were you couldn't be a lawyer for 3 years. But can you share with us the facts of that, mitigate that conviction?
And the petition also objects to the collateral attack of his theft conviction as well as the ensuing disciplinary case.
Okay, I'm gonna overrule that, but be sensitive to time. Be
Watch
sensitive.
our time, right?
Yes, because it's getting close to cumulative.
Real short.
If I knew at the time that I was settling with St. Paul, what I knew at that time, I would never, ever have dealt with the state or dealt with the bar.
In other words, you
I
wouldn't
would
have,
have tried the case all the way. I just didn't have the information. I didn't know what had happened. I didn't have files to defend myself.
and you got them after the suspension and after the conviction. You got the information.
Some of the files are still at the Boise County Courthouse.
Right, but this lost information, some of it came to your attention after you pled guilty.
After we took depositions and after we found out what had happened, yes.
But that's after the plea of guilty.
Yes,
That's after the commission gets their reprimand.
yes.
Many lawyers come in front of BOTA in the Supreme Court, and they don't have the kind of past record you have. How do you tell BOTA that in the future, if you get your license back ever, that you won't be that kind of lawyer anymore?
I've learned from my mistakes. I realized that just having more and more clients and getting bigger and bigger settlements, it's a recipe for disaster. And if one client out of 1,000 complains, and I'm not, I'm responsible for every agreement I've made, every paper I've signed, and I'm not trying to skirt out of it. But what I've learned is you just can't do that volume without hurting the public. It's just impossible. I'll be the first one to say it. I thought I did things as well as I could. I think I did things as efficiently. I think I had lots and lots of happy clients. But I haven't been able to help those clients since 2006. So look where I am today. It's one of those things where I will not return to that type of a practice. I have an opportunity to continue working as a legal assistant with Larry Laurent for the next 13 months, and then hopefully, if the board agrees to sanction me with a suspension, I will be able to practice and take over the lien practice for Attorney Larry Laurent. And I've known Larry Laurent for 20 years. John Bone and I used to walk into Larry's office when I was a lawyer and John was a medical provider, and Larry had the advice from all the clients that he represented, all the years of experience he had, both representing doctors and personal injury cases. So I considered Larry Laurent he was my lawyer. I paid him to be a client of his, and now he's my boss. And I'd like him to be of counsel. I'd like to have the opportunity to take over his practice, and he's offered that to me. And it's a different kind of practice. The clients are white-collar professionals. They're doctors. I've always, most of my friends are doctors. I follow medicine. I try to stay abreast of changes in the law. But this lien practice is really my niche. It has a lot to do with insurance coverage, and there's a lot of remedies that I've been able to work with Larry to get for his clients. If the board would give me a chance, if the board would give me one more chance, I'll make sure that you don't regret that you had given me that chance. I really with these people, not what the insurance company wants to allow, not 12 visits or anything with Obamacare. This is on a letter of protection or a straight attorney lien. Then it's known that what the doctor prescribes is what treatment that patient's going to get. So it's a better system than going through insurance. And Larry Lorenz, he put this lien practice together years before I even knew it existed. And when I came along in '87, we talked, and he shared what was going on. And he's been very, he's been great to work for, and he's not going to let his reputation slide. He's going to watch me, and so the board will know that Larry Lorenz is going to make sure that I practice law properly, correctly, and not make mistakes if I'm given that chance.
And you and I talked to Mr. Laurent yesterday on the phone,
Yes, we did.
and he said that he wouldn't like to retire in September 1 of 2015, right?
Yes, next year.
But he wanted to be a 25% to a 40% lawyer after retirement to watch his office and watch over you and make sure things are done right?
Yes, he did.
And he's about my age, right?
I think he's
40 years in the bar?
67, he said he was.
Right. But about 40-year lawyer?
Yes, oh yes, 37 years, I believe.
Now, barratry is one of the more serious things a lawyer can do. We know that. The legislature calls it one of the few listed serious crimes that the board POTUS rules say it's an intentional crime. The Supreme Court lists that in your opinion. It's a printed opinion. And this ain't the right question, but it gets you in the area. Why do you feel you've been punished enough? And I apologize for that question, but we got short on time.
Okay, well, for the last, since my sentencing in 2002, I haven't had any criminal charge other than traffic ticket level offenses in the last 12 years. I haven't even had a traffic ticket in the last 5 years. Then the board's heard about this 21 counts of misconduct that I felt like that, helped me, myself. If it helps mitigate, if it counts, it's fair, but I felt that showed that I at least wound down and wound up my practice properly. I felt that was critical to me, every attorney who practices law, is get my practice wound down, not abandon clients, and not leave people hanging. And I think I did a good job of that. And then 2 weeks ago, when I got the judge that heard the case, that gave me a J&OV acquittal, that ruled that the statute of limitations had run, and ruled that there was...
Let me stop you there. We've always said that, but he never ruled that. He just gave you a clemency, knowing all those things were back in the record.
Oh, well, he did that prior, and it went all through appeal, and then when he finally granted the clemency, it set aside the conviction. And I know this law might be one of the cases for suppression, but I don't want to have to go to the Supreme Court. I've already been to the Supreme Court twice on this case. I'd like to get the sanction of just the suspension for another 13 months. I guess to do the math again, in 2002, had I just not appealed and taken a disbarment, 5 years later in 2007, I could have got relicensed, and I could have been practicing for 7 years. It was that important to me to wind down my practice the right way, take care of those clients, fight, and get as much as I could of a victory out of it.
To try and get an appellate court to say the judge made a harmful error when he overruled the limitations issue that we presented to him before the jury trial started. That was what our appeal was all about, ultimately ended up all about, right?
Yes, it was.
And that and the issues of the Brady, the government hiding exculpatory evidence, mitigating evidence from you prior to the jury trial. We litigated that at the motion to trial, right?
Yes.
And that was the other big issue that went up on appeal.
Yes. Brady all over the place.
I'll pass the witness.
Ms. Stevens?
Mr. Mercier, I think I'll try to go backwards here from what you all just finished talking about. I think Mr. Connors mentioned that the basis of your motion for new trial was Brady and some other things, and that's what you were appealing, correct?
There was a acquittal, and there was statute of limitations that run, and there was Brady violations, yes, 3.
But that appeal was eventually unsuccessful, correct?
That's correct.
Going to the civil trial that the commission filed against you, the 21 counts that we all know now, jury came back in your favor, that's right?
Yes.
The allegations, though, surrounded conduct that occurred prior to your suspension by the board
Yes.
in 2006. So 2004 to 2006 timeframe, does that sound right?
Yes, nothing was after, it wasn't a situation where there were complaints. It was after November 3rd, 2006 when my suspension started. It was all prior to the date of my suspension, yes.
But your trial in the commission's case didn't actually go forward until 2012, is that right?
That's correct. January 30th, 2012.
So a 6-year timeframe, difference between the alleged conduct and when you actually testified before the court.
That's correct.
You said that, I think Mr. Connor's question concerned whether you thought that you had been punished enough for the Beartree conviction. And you talked a little bit about that, right?
I think he meant punished enough for everything, but for the Beartree conviction as well, yes. And I do think I have, yes.
If I may, let me correct, it's a conspiracy to Beartree. It doesn't mean much to you guys, but legally it's a conspiracy.
Pardon me, conspiracy to commit Beartree. But in fact, you didn't actually end up serving your full term of probation under the criminal judgment, correct?
The judge ordered that I did, and I had complied with substantial amounts of, and paid the entire fine, did all the courses, and was compliant with everything. I had a problem completing all my community service, but I did a lot towards the end, and I did all the as much food donation I did over the top, even more. I even started volunteering before I was able to.
And you had, how many hours were you assigned for community service? 240, is that right?
Yes,
And how many did you end up completing?
I think about half.
But as for the probation itself, under the terms of the order that you recently received from the trial court, you served about 1/3 of your probation, correct?
Yes, I was eligible at 8 months, and I think we came in at 9.5 months. 10 months.
And I think you talked about this a little bit. It sounds like you are trying to mitigate the past sanctions by the commission and the bar, but you do agree that I think every one of your disciplinary orders are agreed. Is that right?
Absolutely. I am responsible. I signed, I agreed, and I stand by that. I'm not questioning that.
I'm going to switch gears here real quick. I've got a certified copy of the very short hearing on your motion to reduce an early terminate period of community supervision and to grant clemency hearing.
Yes.
And so
Can I just ask the date of that?
it's the April 17th hearing. Yes. May I approach the witness? Sure.
You're saying that's the transcript of the hearing?
It is.
I believe that's before the vote as one of the exhibits earlier.
It was attached to our, I think it's titled the response to the respondent's reply to our petition. So it is attached, but you all should have a copy of the full thing. Mr. Mercier, if I might direct you to page 5, you have a very short colloquy with the court, and if you would, I'm going to read what the judge says, and then if you'll read through line 14, I would appreciate that out loud to the board. The judge says, "Tell me about yourself, Mr. Mercier."
Your Honor, I have learned the mistakes that I have made. I was in a position in my life where I believed that if 2 were good, then 4 were better. I learned that if I had too many cases, I was going to get in trouble. I got in trouble, and Your Honor, I want to get out of trouble. respected lawyer that I've known for 15 years to work his lien practice. I wouldn't return to personal injury law.
And let me stop you there, just because that's cumulative of what you already testified about. The board has the whole hearing in front of me. I just want to make a point about 2 sentences up. You said, I have an opportunity to return to the practice of law in 14 months if the Board of Disciplinary Appeals allows me to be suspended instead of disbarred.
Yes.
Right, you just read that. Where in here do you tell the court that should you get this judicial clemency, you were going to argue to this board that the board could not act?
Oh, I didn't tell the judge that.
Okay. I'll pass the witness. Actually, I'd like to offer as Exhibit F the trial transcript. This is
No
the
objection.
certified copy. May I approach?
Yes. Mr. Connor, and let me check on your time, both parties' times.
Mercier has 14 minutes. And the commission has 36 minutes.
Thank you.
Mr. Mercier, when we were waiting for Judge to take up your case on April 17, 2014, you're aware that the state lawyer and your lawyer went back into chambers and talked to Judge, right?
Yes.
It's become a sworn witness in my own hearing, but we had a nice meeting, and let me talk to counsel. If I may. Our side has a stipulation we'd like to offer, that in that chambers conference with Judge Ramirez, and Kyle Webb is the prosecutor that was there at that time, I did mention to Judge Ramirez that if he would grant the clemency, that we were going to present that, of course, to Bodo up here, and maybe that would help Mr. Mercier not be disbarred and be suspended. But we'd have to wait and see what Bodo did, but that Mr. Judge Ramirez, that's what Joe Connors wants to use if you give me the clemency. And then his response was, let me think about it. Is that accepted?
That's acceptable to the commission.
Okay, thank you.
Let me make sure, you're saying you told the judge that you believed it would be helpful to him, to Mr. Mercier, if this occurred in his efforts to just be suspended through June of 2015?
I don't know that I put a date on it, but yes, sir, be suspended versus disbarred. And I know my prosecutor at that point said, it's not in the stipulation, but Judge, they're just asking for a professional courtesy, which I heard sort of whenever I go to court with a lawyer, that's what the prosecutor talks about. It. Should we give a professional courtesy because he's a lawyer within a criminal case? But go ahead, Mr. Kidner.
Well, I thought the import of her question at the end here was more to the effect of, you didn't tell the judge that you would then in turn be coming here and making the legal argument that you've made to us today. That's what I heard.
She's asking Mr. Mercier that. He's not in the chamber's conference.
I understand that, but...
And I didn't tell him all the details of what the judge said in there because the judge told me to keep some of it private.
I understand all that. And I'm not asking you to violate any confidences. You're not allowed to do so.
Right.
My question is, because I got the import of her question to be that the judge was told, do this, and I'm going to come back to Boda, and I'm going to tell them this, and I think this will be helpful that I'm out from under this criminal probation in my efforts to not be disbarred, but rather to get my law license back in June of whatever.
I'm saying all that.
A fair paraphrase.
I'm saying all that to the judge. Mr. Mercier is not in the room. Yes, sir. And
And
maybe
did
not
you-
exact words, but yes, very good job.
Every once in a while. The question I have is, did you tell the judge, and we're also going to make the argument that it wipes it clean, it's as if nevermore, and if the state or the commission wants to do anything, they're going to have to start all over and prove it from scratch, because I heard that was your argument earlier today.
Yes, sir. I don't think I did any, the second question you just did, I didn't do any of that with the Judge Ramirez.
Okay.
It'd just be helpful to us if you'd sign this order today, Judge, and he's been punished enough kind of thing.
Okay, thank you. I didn't mean to interrupt you.
Certainly.
I just want to make sure I understood what you
No,
were.
and you guys weren't in that chambers, and I was.
And, so I think you had passed, and it's still Mr. Connor's witness while y'all visited about stipulating, which we've accepted, so any other questions with the few minutes you have left?
I'll pass the witness.
So, thank you. Unless Ms. Stevens has some other questions, I'm going to offer him to the board. Anybody on the board have questions of Mr. Mercier?
I just have a couple.
Sure.
Ms. Mercier, do I understand, since you were originally licensed 27 years ago, you spent virtually a third of that time under suspension?
Yes.
And your position is that's enough punishment for what you have done, but you don't believe that's any indication of what you might do if you got your license back?
No, I don't think that, for many reasons. First, the climate that was in the Rio Grande Valley at that time, the chiropractors were able to solicit legally, and there were just a lot of promises being made to a lot of these clients that the lawyers didn't know about, didn't know what to do. We had to release clients, refer them, when we found out some of these things. So that's all been outlawed since 2008.
So what you're saying is you're getting out of the type of practice that's caused you to be suspended for a third of your licensed life and getting into something that won't get you in trouble. So you.
Not as much as the practice itself has changed. What happened after 2008, I'd say that half to 3/4 of the problems that I ran into had to do with this doctors getting the police reports legally, and legally soliciting people to legally come into their clinic, and then the people legally asking to have an attorney recommended to them, even though it was not against the law. It created a lot of ethical problems because so many people were trying to make so many dollars from so many different angles that these poor clients got promised so many different things from so many different people.
You
There
being
were even people saying that they were with the insurance company.
you being one of those people that was profiting by all of that.
I made my 29%, and I think I was as fair as any lawyer that I've never heard of a lawyer charging less than.
What do you do? What have you done for these 9 years that you've been suspended?
I spent 6 months just manning the phones and watching the mail and making sure that there weren't any problems, and that's what that trial was about, is making sure that what needed to be done got done. And then after those 6 months, I just sold both the condos I had, paid lawyers, basically lost everything, and then went to work for Larry Loren and started asserting liens and fighting to get these medical bills paid for these doctors.
Yeah, that's all I have.
Anyone else on the board might have any questions for Mr. Mercier?
Do you have any questions?
I don't.
I want to make sure I understand just in looking at Mr. Gerwitz said a third of your career. The way I actually look at it, it looks like you had 3 years actual suspension and 4 years suspended, probated. So that's 7 right there, correct?
That 4 years was just a probation. So
I understand that, but it was 3 plus 4.
I practiced this 4 years.
7 years, either active or probated.
Yes, sir.
And then I saw 6 months in June of 98 through November of 98.
Yes.
And then there's been 7 years, or really more, almost 8 years, since November of 2006. Is that correct?
Yes.
So that's 14 or 15 years out of a 27-year career.
Yes, that's right.
And how long have you been working for Mr. Lorenz?
For about six and a half years.
And what do you specifically do for him?
I assert liens under his letterhead as him being the attorney of record, and I work as a legal assistant. I follow up and make sure that the insurance adjuster notes and sometimes writes a confirmation letter back saying that they're going to honor that lien and make Larry Lorenz payable at the settlement check on behalf of the doctor, the client of Larry Lorenz. And then a lot of times there's administrative, making sure that the check gets sent to the right place, that the right people are doing all the things they need to do so that the doctor gets paid.
Is there any other business, law business, that is operated out of that office?
Larry does about 90% representation of medical providers. I don't really know what else he does. That's all I've ever known. He's a business lawyer.
My question is, other than the lien business that you work on, is there other business that is done by anybody?
Larry teaches practice management. He's teaching a seminar this weekend, for example, to maybe it's the Texas Chiropractic Association. He writes articles for the Texas Chiropractic Association in their monthly journal. He writes prolifically and publishes.
You're not answering my question. What I just want to know.
Business law practice.
Well, you're telling me you're going to take over his practice in a year and a half if everything works out. What does that practice consist of other than the lien practice?
He does, he's working on medical.
I'm not asking what he does. I'm asking what you would be doing in a year and a half if you took over his practice. Would it be anything other than liens?
Primarily liens. Larry does representation before the Board of Chiropractic Examiners. I think he would continue doing that, but I'm sure I would do the intake for that, and I've been familiar with several of those cases. He does the medical practice integration, where he works the right ICD-9 codes and makes sure that the doctors are billing properly. And I've had extensive training in that area, and I've followed along with what Larry's doing with the practice management side for the doctor, provider, clients of his.
Okay. And all of your dealings with the state bar, all the private reprimands, public reprimands, suspensions, active or probated, have you always had a lawyer representing you?
No.
On which ones did you have a lawyer?
I was the stupidest person probably walking in this room. The first time, I didn't have any signed contract or anything, and I don't even remember responding to it. I don't know if I did. I don't know what I was doing. So I was completely retarded about that. So I certainly didn't have a lawyer help me there. Then Claude DeClue helped me when this matter happened in 1990, and so I did have representation there. And then in 94, 95, I don't remember when the first matter came up, Jim Harris represented me. And then there were periods of time when Jim Harris would ask me to just take certain cases pro se and just to be efficient. My goal was to put the client first and just make sure that I was handling my existing clients and for judicial economy and just to cooperate. I just took Mr. Harris's advice, and he helped me even though I was pro se some of that time. And then Mr. Harris he's in his 80s now, so John Flint came in and helped me after that. So I had Claude DeClue, Jim Harris, pro se, and John Flint.
And then Mr. Connor?
And Joe Connor's been my criminal lawyer. This is the first time he's represented me in a state bar matter. Been for 12 years, 14
Other
years.
than us.
Okay, that's fine.
If I can, Mr. Kidman,
That's fine.
When the 13th court came down and said it was a case reversed and we thought we were winning, then I came to you guys and said, could he have his license back while we went to the Court of Criminal Appeals? And I was his lawyer at voted on that.
Thank you.
I forgot, I'm sorry, he took it to the Supreme Court then.
Okay, thank you very much.
Any other questions from any of our board members? Okay. Mr. Connors, do you have anything else, or Ms. Stevens, of this witness? Because I think we're running.
No, we're close to out of time. I offered all those affidavits of people with the statement that I'd call them to the witness stand. There's been reasons why I can't call them a witness stand clock. So I still, you accepted them. I asked you to reaccept them. I know she's got her great hearsay objection, but
Right.
I couldn't get them here with the time limits we were working
No,
on.
we accept them. Thank you. They're admitted.
I don't have any more questions, Mr. Chair.
All right. Mr. Mercier, you may step down. What is Mr. Connors' time left?
13 minutes and 7
Thank you.
Let me pass
Surely.
right now. I tried to get Mr. Laurent. He can't get a notary.
Would you like to proffer his testimony? We indicated we would allow you to do so if you wanted to.
That'd be fine. Mr. Laurent, you see his affidavit, that'll be before you. He's a lawyer. At one time, he was, I think, a lawyer helping State Farm adjusters, and he'd come in and give them classes and stuff of how to be a good State Farm adjuster. And he did that in Texas, and he did that in Louisiana. And so all of a sudden, Mr. Mercier got the bright idea, why don't you come to my office and tell my office sort of what the adjusters are thinking and how we can work well with the adjusters and work these cases out and stuff. And so Mr. Mercier had him as a teacher there quarterly. Okay, this is what Mr. Laurent, or Larry Daniels would be saying. I'm sorry. I'm sorry.
That was all Daniels.
I'm sorry. Larry Daniels is the one in Utah. I'm sorry. Mr. Laurent's the local lawyer who couldn't be here. And so, but I won't stipulate as to, proffer as to him. I want to proffer as to Utah, Larry Daniels. I apologize.
Okay.
And everything I've said so far is Mr. Daniels talking through me. Thank you for that correction. I think it's about wheels, cars. Mr. Mercier had the practice that Mr. Daniels was aware of and thought exemplary, that if a person doesn't have any car because of that accident they just had last week or whatever, that Mr. Mercier's staff would call daily to check on can we get you a rent car, et cetera, so you have some wheels to go about your life. Without a car, we're sitting at the house unless somebody's going to drive us. And a lot of the people that Mr. Mercier represented they couldn't go down to Enterprise, Avis, and Hertz and stick their credit card up there and drive away. They just couldn't do it. So they had to get help. So Mr. Mercier did a lot of that. The 2006 suspension of BODA, which is what had to happen under our rules, ultimately caused a great financial hardship to Mr. Mercier, and he's lost most of the assets he built up over the period of time that he'd been a lawyer, since '87, I think the early thing was. So financially, it's hurt, and that's not really, doesn't protect the bar, but that's a reality in his life. I think that's all of the proffer of Mr. Larry Daniels, the Utah professor.
Thank you.
And I think that's all the proffer, and I'll do.
Okay. And no other live witnesses? In your
No more live witnesses, no ma'am.
Thank you. Ms. Stevens.
Okay. As to Mr. Daniels, just since he's been offered as a fellow attorney, I think in his affidavit he goes into that, about the fact that they went to law school together, so on and so on. I would have pointed out, had Mr. Daniels been here or via telephone, that he is in fact administratively suspended.
Okay. Thank you.
If that's a fact, that's a fact, so we'll agree.
What is he administratively suspended for?
That is an excellent question, and I didn't write down that part. I think it might be Texas. So at this time, would Boda like me to make my argument as to why you're legally able to act?
It is your time to use as you see fit, so but that would be fine.
As a part of your argument, please address whether you think this is a case of first impression or not.
I will do that. It's the Commission's position that Boda can, in fact, act in the situation that is presented to you today. And I'm going to address several things, but first of all, Boda has considered the almost exact situation in Boda and the Supreme Court, in Lejeune and in Goldberg, and I think one or both have been cited in our response.
I'm sorry, Goldberg, and the other one is?
Lejeune. Additionally, Boda's acted in the same procedural situation in Javrid, who is also, that case is also cited in our response, and I'll talk about that a little bit later. Under 4212, Section 20, Mr. Mercier's conviction still stands for the purpose of compulsory discipline. And we've talked a little bit about whether 4212.20 judicial clemency equals a pardon, and so I could not find any case law, nor has Respondent cited any case law that says that it's the same, but even if it is the same, you would have the same result. Boda could still act. Is this a case of first impression? This exact same scenario, with the timing of everything, has not been heard before the board. So I would agree that the facts is exactly as they're laid out have not been presented before. But there are three very, very, very similar cases that the board and the Supreme Court have ruled upon. 4212.20 judicial clemency does not render the conviction of Mr. Mercier a legal nullity. I have a case that was not cited in our response that I'd like to give to the board. It's DPS versus JHJ out of the 14th Court of Appeals. It's a 2008 case. And may I approach?
Sure.
Counsel provided me that during the break.
Thank you.
In that case, the court was considering whether JHJ was eligible to have his conviction expunged. And an expungement proceeding is a civil proceeding, and that's why you have the DPS as the opposing party. But a quote out of that case is, quote, notwithstanding the broad language of Section 20A, releasing the defendant from all penalties and disabilities, the consequences of such a dismissal are quite limited. Section 20 operates to restore civil rights to vote, serve on juries, and hold public office that were lost by the conviction or accusation of crime. However, the dismissal is not an exfunction and does not preclude other collateral consequences of a criminal conviction. There are several instances in Texas that can be analogized to this situation where a party has been convicted and then given judicial clemency, and then those convictions are still used against them in other proceedings. I have four different ones listed. A convicted person cannot become a police officer, and then if they are a police officer, they can still be, their license to be a peace officer can be taken away. And there is a Texas Attorney General's opinion, MW-148 from 1990, discussing that. As in the DPS case, they decided you can't get your record expunged. That's a civil proceeding. They distinguish between the penalties and disabilities that come with the conviction from the non-penal sanctions that might occur still as a result of the conviction. And another Texas AG opinion, JM-1237, 1990, opined that you must still inform a prospective employer about the conviction when asked about your criminal history, despite a judicial clemency under 4212, Section 20. And in that opinion, they talked about a prior AG opinion and said an individual who qualified under this provision may serve on a jury or vote at an election, provided that he's otherwise qualified. These are civil rights which the statute seeks to restore to such defendant. The prior opinion emphasized, however, that since no provision is made for expunging the judgment of conviction from the record, the statute makes it clear that the conviction itself has not been entirely erased. Pardon me. The Commission points out that the 4212 Section 20 judicial clemency does not exonerate respondent, nor is he even making that argument here today. Third, the 4212 Section 20 disabilities and penalties does not prevent a compulsory disciplinary proceeding. This is not the type of disability and penalty that 4212-20 is talking about.
Would you not drop your voice?
Yes, I apologize. In Lejeune and Goldberg, specifically in the conclusions of law in the Lejeune order, this board said that the disbarment is not a disability or penalty under this section, 4212, Section 20. In Texas, they're similar to proceedings against attorneys for these convictions. You also can have these type of proceedings against peace officers. And I believe in the AG opinion that we cited in our response, they said that despite receiving judicial clemency under 4212, quote, an individual's release from all penalties and disabilities is not effective to prohibit the Commission on Law Enforcement Officer Standards and Education from revoking his certification as a peace officer. And then, as Mr. Connors pointed out, we discussed several California cases that California has an analogous penal code provision that allows for the disabilities and penalties for certain convictions to be, I think the wording is released. And they did, in fact, disbar an attorney who, well, he was disbarred and then he received the judicial clemency after that. And I think that's in Ray Phillips that we've cited in our response. As to the respondent's argument that this is somehow a pardon, there's been, as I said, no case law that says that it is the equivalent of a pardon, but I did go ahead and search for cases that involved pardons. And the Court of Criminal Appeals has previously held that a pardon, quote, forgives only the penalty and does not direct the courts shall forget either the crime or the conviction. And that's Watkins v. State, 572 Southwest 2nd, 339. The Court of Criminal Appeals also said that since the very essence of a pardon is forgiveness, a pardon implies guilt. It does not obliterate the fact of the commission of the crime and the conviction. And that's Jones v. State, 147 Southwest 2nd, 508. And I would be happy to answer any questions that the board has for the commission.
I thought of one when you were, and I haven't thought it all the way through, because I just thought of it when you made this comment, but that case that says that the pardon only forgives the penalty. If I'm thinking about it, and maybe I'm making it circular, but you know, we're limited in what we can do in these situations. We can either suspend if there's been probation for the length of the term, or we can disbar. But then if we try to apply your case, and I want Mr. Taylor's help on this since he's the criminal defense lawyer, but if we apply that case, I'm just thinking out loud, and the pardon, clemency, forgives the penalty, okay, which in this case was the probation. Let's just say it wiped it out. Let's do that for argument's sake. Then it looks like the only thing we would have left to consider would be disbarment, which seems to be contrary to the whole fact that if he was deserving of clemency, it seems like we at least ought to be able to consider something. So I'm just asking, how is it that case, using that definition of pardon, really applies to what we're doing here?
Well, again, I've only mentioned anything that talks about pardons because of in response to respondents' arguments. I think we can focus on 42-12-20 and stay there, and that would probably be the best course. But I broadened it just so we would have a response as to the pardon. But the respondent's probation has been early terminated. He doesn't have to continue to finish out the probation. But I think the board still has the discretion to suspend or disbar him based on the language in our rules. If you look at 801, it talks about us being able to bring a case before you even for deferred adjudication. And in that case, we could bring it after the deferred adjudication was complete, and then there's not even a conviction. And so I think the board would still have the discretion to suspend or disbar in that case. And so that's would allow you to do something here.
I have a question.
Yes, sir.
You offered JHJ really for the dicta in here, didn't you? Not because it was reversed and he was not granted an expunction.
He was not granted an expunction.
Right.
That's right.
So you're really talking about the dicta that's in here.
Well, the point is that the expunction is a civil proceeding, and so it's not the type of disabilities and penalties that were meant to be released as to JAH when he was convicted and then later received the clemency.
And of course, he hadn't asked for an expunction, and he does not have an expunction in this case.
Mr. Mercier?
Clemency, yes.
Correct. The point is that there are several instances in Texas where you can still use a conviction that the defendant has been granted judicial clemency. You can still use those convictions in various ways. So the peace officer example, the Toon case, I understand Mr. Connor's distinction, but the point was that it's also the conviction's able to be used in that concealed handgun instance. And so that was my point in giving you all the JHJ case.
Is it correct that, let's assume that the clemency order had never been entered?
Okay.
Would our decision be either suspend through June of 2015 or disbar? Those are two choices.
If the April 17th hearing had never happened.
Had never happened.
Yes, I think that's correct.
Those are our two choices, one or the other.
Right.
There's not a third. Do you agree?
Yes, I agree with you.
Okay. Now, I've heard Mr. Mercier saying, no, I wish I was smart enough to ask trick questions. I've never been, so. But Mr. Mercier, I hear, is saying he's willing to be suspended through June of 15. That's what he's asking us to do instead of disbarring. Is that right?
I heard the same thing.
So I'm wondering, why are we talking about this?
Well, the commission's position is that Mr. Mercier should be disbarred.
I understand that, but we have that option, and I know he's arguing that we should go ahead and suspend him through June of 2015, which you say is one of our options. You also admit, and I think I don't know that he admits it, but the other option would be to disbar him. So if he's willing to serve the remainder of his thing, why are we talking about this statute? Is it your position, Mr. You see what I'm saying?
I understand.
Unless Mr. Connor is saying the only option we have is suspension, because that's okay, but not disbarment. And I don't know how you can have it only that way. So I'm just trying to figure out why we're talking about it.
The reason I'm addressing this on behalf of the commission is that I did not understand Mr. Connors to have waived his argument as to the fact that his argument that the board cannot even act. And so that's why I'm addressing it.
Well, I don't know if he has or not. When I hear Mr. Mercier saying he expects to or is willing to or recognizes that he can be suspended through June of 2015, I'm wondering why we're talking about the statute. So that's just me. Thank you.
I hate to keep going back to JHJ, but in that case, did either one of you cite the Cuellar case?
Is that Cuellar.
Yes, Cuellar.
That's in my original motion to the Judge Ramirez to say he can do this.
That he could do it, but also the Cuellar case, which is a 76 case, has some pretty strong language in there about clemency. It's actually helpful to the respondent in this case, or the appellant. I don't know what you are at this time. This thing's been back and forth so many times.
I'm still the respondent, I think, and she's petitioning.
There you go. If you read that, and this is your case, Ms. Stevens, but on page 10 of 16, if you look at third paragraph.
Pardon, we're talking about JHJ?
Yes, JHJ. But it talks about judicial clemency under Cuellar. The judge may set aside the verdict or permit the defendant to withdraw his plea and shall dismiss the accusation, complaint, information, or indictment against the defendant, who shall thereafter be released from all penalties and disabilities resulting from the offense or crime of which he has been convicted or to which he has pleaded guilty. These words are crystal clear. There is no doubt as to their meaning. If a judge chooses to exercise the judicial clemency provision, conviction is wiped away, the indictment dismissed, and the person free to walk away from the courtroom released from all penalties and disabilities resulting from the conviction. Do you believe that that law has changed? That Cuellar case has been overturned?
It has not been overturned, but there have been subsequent cases.
And Lejeune, you say is one of them?
Well, Lejeune is specifically before this board, but the Court of Criminal Appeals has made further statements about this after Cuellar.
And what are those?
And I'm going to quote from the court. It says, appellant's mistake...
Which case?
Pardon.
Cite the case.
Yes, thank you. Smiley v. State, 129, Southwest 3rd, 690.
Give me again.
And I said that's a Court of Criminal Appeals case. That's a Texas... it's a Court of Appeals out of the 14th Court. It's Smiley v. State, 129, Southwest 3rd, 690, and this is quoted extensively in our response. But I'll read from that if that's okay. Appellant's mistake is in equating his conviction having been set aside pursuant to 4212 Section 20 with his never having been convicted at all. Hence, with his being they go on to talk about community service. Oh, I'll just read the whole thing, sorry. Hence, with his being eligible for community supervision pursuant to 4212 Section 4E, it is well established that, under the Code of Criminal Procedure, a prior felony conviction makes a defendant ineligible for jury-recommended community supervision. This ineligibility applies even if the prior conviction is somehow set aside or vacated, unless there's an express finding that the individual was exonerated from the prior finding of guilt. Although appellant established that the prior felony was set aside, no evidence established that he was exonerated of the offense. We hold that appellant's set-aside prior felony conviction rendered him ineligible to receive jury-recommended community supervision.
Well, I understand he's not exonerated. We've established that. I don't think anybody here is claiming that, including Mr. Mercier. You know, I think we're all on that same page. So that's all that says, as far as I'm concerned. I still don't see how that changes the language that you cited or that's in Cuellar, which is cited within JHJ. That's pretty strong business, as far as I'm concerned. I don't see a case that changes Cuellar or overturns it.
I agree with you, but there's been distinction made between the penalties and disabilities that are meant to be released by 4212 Section 20 and non-penal sanctions that can still ensue from the conviction of the crime.
And what case cites that?
Well,
I didn't see that in that case, the part that you were reading.
You're right.
In Smiley.
We cited various cases out of California, as well as Attorney General opinions in Texas and the Lejeune order, VOTA order.
Okay. Which of those cases, and give me the site, if you would, do you say distinguishes Cuellar, I guess that's what you're saying, as far as disabilities, I think you're talking about, penalties and civil disabilities, which is what we're talking about here. Okay? So which one of those cases does that, if you don't mind?
Well, in Ray Phillips, they discuss the penalties and disabilities that the penal code that's analogous out of California. They also say disabilities and penalties. And in Ray Phillips, it says the statutory language. Pardon, I'll give you the cite. It's 109 P. 2nd 344.
So that's a California case.
Yes, sir.
Okay.
Would you still like me to read
Which
from it?
Which Texas case?
The Texas Attorney General opinions. Give me a moment, I'll give you that cite. The first one is Texas Attorney General Opinion MW-148. And I actually have that opinion if the board would like it. May I approach?
Sure. Do you have another one?
I do. I'm looking for that. Give me just a moment, please. Texas Attorney General Opinion JM-1237. And that opinion cites a prior opinion M-640. And I don't have copies of either of those. I apologize.
So you've got a California case and two Attorney General's opinions, but no Texas case.
That's correct. The Lejeune order is, I would offer that as additional.
Okay. Thank you.
Can I ask a question about some language in this, whatever this order is, reduced early termination, etc.? At the very end, in the broadest possible language, it says, you know, forget about it all, like it didn't happen. But then it said, except that proof of said conviction shall be made known to the judge with a little j, should defendant again be convicted of any criminal offense. Does that mean that although you don't consider it for anything, but it can be used against him for enhancement if he does anything else?
There are two exceptions actually listed in 4212 section 20, and they're in section, they're 1 and 2 under section A.
Right.
And it talks about the proof of the conviction being able to be used after a later conviction. And the cases I've read use that to not allow the defendant to sign the motion beforehand saying that they've never been convicted before, so that they won't be eligible for community supervision after. And I've not practiced criminal law, correct, but that's the way I understand that is usually used. So there are two specific exceptions under the statute, and that's, I believe, what the order is quoting.
When did you first know about the proceedings before Judge Ramirez?
The request for judicial clemency proceeding, April 17th, when I received the email that I think all of BODA also received.
After the fact.
Correct.
I think Mr. Connor had mentioned that said before.
That's when I sent it to them and to your staff. Judge, certified copy, obviously, Judge has already sent it.
Does the commission claim any requirement that it should have been made known?
I hadn't actually thought about that. I suppose the district attorney might have been able to make an argument one way or the other had we been informed and been able to discuss that, but I'm not ready to state the commission's position on that.
Any other questions? Anything else you need to present, Ms. Stevens?
Well, I would like to do a closing as to why he should be disbarred, but I don't know if there's any.
Sure.
You're ready for that?
What is her time remaining, just so we can keep track?
27 minutes.
Okay. Surely you don't need all of that to explain.
I think I might be able to get some back.
Thank you.
May I proceed?
Please.
As I said in the opening, the commission requests that Respondent Mercier be disbarred. The pertinent factors that have been laid out in Filipov and additional cases thereafter, there are three that come to my mind. Respondent's conviction was directly related to the practice of law. It's a conspiracy to commit barratry. And I would just like to point out the 1894 case that Mr. Connors cited. The statute that's used to attempt to pursue the disbarment in that case also prohibited barratry at that time. So it's been a long time prohibited. Respondent's credibility under oath is another factor. I would submit that the statements made before the district court to get this clemency at the very least omitted that the argument would be made that the board couldn't act thereafter by saying that he would be suspended or disbarred. And lastly is Mr. Mercier's disciplinary history. I think the board has all of this in front of them, but Mr. Mercier was licensed in '87 and then sanctioned in '88 with a private reprimand. In '99, he got a 7-year partially probated suspension, 3 years active. In '95, he had an agreed judgment of 6 months fully probated, and he was still on the probated suspension for the 1991 judgment when the acts, the conspiracy to commit barratry occurred. If you look at the judgment documents, it says that the conspiracy to commit barratry occurred in September of 1997, and he was still on that probation at the time. In 1999, he had an agreed judgment of private reprimand, 2 actually in 1999, and then in 2006, a public reprimand, and 2007, an agreed 1-year active suspension. I think the commission submits that with his lengthy disciplinary history and the conviction being directly related to the practice of law, that Mr. Mercier should be disbarred.
Anything else? Anybody have any more questions of Ms. Stevens? Okay, thank you. Mr. Connors.
The word timing was used a couple times by petitioner about her prior cases that she's citing us to, and I'm not sure if we all catch what that means. So let me just real quickly. In Lejeune, Goldberg is best. I remember that one clearly. He gets his disciplinary disbarment from Boda, and then 2 years later he gets one of these clemency hearing things back in the trial court that I got on February 4th, April 17th. And then he runs back in and says, "Give me back my license. This judge gave me the clemency 2 years after I got disbarred. I'm entitled to practice law again." And of course the Supreme Court said no. And now we refer to that as a timing issue. Which one came first, the chicken or the egg? The disbarment order from Boda or the clemency order? I got it backwards from Goldberg. I got the clemency order first from Judge Ramirez. And remember, he tried this lawsuit. He's the judge that sat there for about over a week with this jury and the facts. So that's the timing issue. First impression, we've never been here before. As far as Boda and the cases that I can see. And yet, Texas law, Scott, has been clear since 1894 what you're supposed to do in this kind of situation when you get the clemency. They called it a pardon then, that'd be from the governor. I call it a clemency because it came from a trial judge, and it instructs. And I understand what Mr. Gerowitz is saying. Over a third of Mr. Mercier's lawyer life has been under suspension, either active or inactive. Probated suspension. I'll call it active or probated. That's, I don't pat him on the back for that. That's wrong. But what we're trying to tell you is, if you're practicing law where you've got 2,000 clients a year, new clients a year, we're human beings. We're going to make mistakes. And some of those mistakes end up as a reprimand and in a grievance system, and he comes along and just signs off on them with his lawyer and never fought. State Bar says it is something wrong, where do I sign?
Did you read the 1988 private reprimand, where nearly over a quarter century ago, a grievance panel essentially said in the final paragraph, you can expect no further leniency for future violations of the disciplinary rules?
I missed that, Mr. Jones.
And are you now asking us to grant leniency by suspending rather than disbarring?
Yes, sir, because the law requires it. And I thought the facts required it too. That's what we tried to put before you in the affidavits, and we tried to put before you in the testimony today, that he's learned from these lessons, and this idea of having a manual. We got to follow the manual. Every time he signed up on a reprimand with the State Bar, yes, I'm guilty, sanction me, he'd go back to the office and he told you it was an issue. We took care of that issue. And I think if you check each of the different reprimands, they're not the same one. We learn from this mistake, and we go on in life, and we get another one, and we learn from that mistake, and so it's never repeating the same thing. I don't know if you should bless that or not, but he has learned from these things. He wants to, if he can get his license back, he wants to turn to another type of practice of law that won't be helping the folks like he used to help, but 25,000 of them in his career. That's it.
Can I ask Mr.
Sure, Mr. Gerowitz.
Mr. Connor, Mr. Gerowitz, we've only known each other for 40 years.
My first case was against you, so we go back a long way.
It's a little awkward being formal, but I need to ask you, I don't understand the argument that he had 25,000 clients from which he made a whole lot of money.
True.
But since he had 25,000, he's only human, he's bound to have screwed up sometimes. So relatively, let's give him clemency because he just messed up on all of these, and he had 25,000, and the public is fortunate that he didn't screw up more often. I don't understand the argument. I'm having trouble with. Is this proportional now? If you only do so many bad things, and out of so many, that we ought to have clemency, or whatever.
If I could add to his question, because I heard the 29% several times. It almost sounds like he had all these clients, and so obviously there was bound to be a problem somewhere. The law of averages, or statistically, it was going to catch up with him. But look at all the good he did for these people by only charging them 29% and not charging them expenses. And I think he said $2 million he saved. I don't remember where that came in, but something along those lines. So it sort of add to Mr. Gerwitz's question, if I can, does that matter? That he, number one, supposedly helped all these people, and there were lots of them, but he had relatively few problems, or at least only relatively few problems were asserted, alleged.
And then the State Bar got their reprimand, and we can read the record. And I think its reprimands are under 10, it's way under 10, and so out of 25,000 people you worked on, and each one of them is a potential grievance if you don't do it right. So, when we went to school, not all of us made 100. Some of us made that 70, some of us made 85, some of us made 99. But we're looking at his career sort of like that. Where does he fall? And I realize I haven't served on both. I've always wanted to, but
Chose that. He deliberately chose that. He went out and advertised.
And
he
got
went
the-
through all of these processes for the very purpose of getting all of these clients that he possibly could, and he made millions of dollars doing it.
yes, sir.
Millions of dollars doing it. And the cases that he didn't try any cases. He referred them to Guy and to other people to try. Why is he entitled to leniency? He got exactly what he wanted, and as a result of overloading himself, he did things he shouldn't have done. And now you're saying give him leniency because of that. I'm lost with that last step, Joe. I can't follow it.
He's learned from those mistakes. That's why I try to hit the manual. Each time he made a mistake, he put that in the manual. We don't do that anymore. And yes, there's too many mistakes, but we don't repeat the same mistake. And
But there's a lot of disciplinary rules. How far does that go?
I understand. And
What about not paying his dues? What about not paying the occupation tax? Completely flaunted all the rules.
and there's a number of them. I think I have one, and it's just I forgot it. It got in a stack. I didn't see it. And
I
I
understand.
paid it as soon as I found that out. But
Seven or eight of each of these, complete disregard for the system. He didn't pay his tax, he didn't pay his fees, he didn't pay his dues, he didn't do his CLE. The system didn't mean anything to him. He was busy getting 25,000 clients
in a short career.
in a short period of time that he was unable to handle, but he kept at it. How do I make the next step? Therefore, give him leniency.
Because since 2006, November 3rd, consequent to your order, which was appropriate, he hasn't practiced law. That's a form of, whatever you want to call it. To me, it's a punishment because I deal with criminal cases all the time. Judge punishes people different ways. He puts them on probation. He sends them to prison. So he's had his hand slapped by Boda. He's really seriously slapped. And that's caused such economics that all these millions of dollars that he was able to pocket and put away didn't pay Uncle Sam. And you did pay Uncle Sam, and then you have a little bit left after is what I'm trying to say. That little bit left after is gone because of the suspension of over 7 years since 2006. And to me, that's a form of punishment.
Isn't that the same as arguing if you get convicted of a crime and you go to the penitentiary, you say, look, I've been in the penitentiary for 10 years. I haven't committed another crime for that whole 10 years.
Inside the penitentiary.
So I'm entitled to leniency. Isn't that what you're saying? He hasn't done anything bad because he hadn't had a license for 10 years. So I can't make the next, I'm trying to understand the argument about giving him leniency because of his past conduct. It's an argument that it's not in spite of his past conduct, it's because of it. That's where I keep getting lost.
I think I go with the in spite of his past conduct, but which he's learned from, and you're seeing that, wow, it's too much. And so that's where we differ. Mr. Kidner?
No, I think you answered my question.
Anything else? Anything else?
Anyone else?
Go back to the CDs. Why do I want you to do that? There's a whole lot of pardon law in those CDs by the professors that I didn't know before I studied this for y'all. Okay. Thank you.
Do any of those relate to?
They're pretty much, there's only a few Texan, but often in a California law review, they'll cite us to a Texas case, obviously.
Right, but do any of those pardon cases relate to a disbarment as opposed to just pardon law in general?
The Watergate, some of us with gray hair remember that, and since then there's been, I mentioned earlier, the White House has some lawyers in there telling him what to do, and all of a sudden break into the Democratic thing where, I forget some of the names, but Hunt and Lynn, starts with an L, they were lawyers. And so then, because of those convictions, various state bars came after him. There's a great case on Mr. Crow, who was a White House inside counsel during those periods of time, and Washington State's taken his license away, and I think I have that in my last filing with you. The thinking of the judiciary that we, protect
right,
the
well,
public.
I think we're all in agreement that the conviction will, can justify a disbarment. The question I'm having is there any case that says a pardon then allows you to get your license back without anything or wipes out the fact that there was a disbarment? That's really my question.
Well, there's the timing issue. The Goldberg obviously answers half of your answer. If you get your clemency after the disbarment, no.
Right.
Mr. Scott, 1894, got his pardon before they filed for their disbarment lawsuit. In the California case, I think 1915 follows Scott, and I got that in one of the filings, that if you get your clemency first from the judiciary, trial judge, then we can't disbar you. So I have 2 cases across the country saying that. I realize they're old. 1915 will be 100 years old in about when he gets off his suspension, if he gets one that Mr. Johnson was talking about.
So your position would be that if you had, in terms of timing, if we'd had this hearing on April 16th, you wouldn't be making this argument? Okay, thank you.
Well, on that note, when did you file your proceeding in front of Judge Ramirez?
April 11th? But to get the to try and get the clemency? You have a copy of it, but I believe it's April 11th of this year.
And I'm not a criminal lawyer, but I'd heard something that he waited 9 months or...
The statute we're dealing with, 4212 section 20, I think it's right in there. You got to do 1/3 of your probation, and then you're eligible to come to the judge and ask to get off early. And if judge will let you off early, then once in a while, I think I have 3 of them in my career, you get the clemency thing too, but judge doesn't have to give you both, and he doesn't have to even give you the first one about, no, I want you to stay on and serve at least half, or you should serve the whole probationary sentence.
Well,
It's all
when
discretionary
this
with
was
judge.
continued in January, from January of 14, was it contemplated you were going to Ramirez?
I've been thinking about this since June when he got the sentence, June 13, 2013. The state bar got a what do you call it, a pass from you, a continuance back in around Christmas, because this young lady's grandma died, I think, and Mr. Mercier got one before I got involved back in July or August or something about it. Yes, Joe Connors had clemency first, Boda second, since sentencing day of June 7th of 2013, Mr. Johnson. I don't have to advertise that, but that was in my head.
All right, fair enough. Thank you.
Thank you.
Thank you. We
Thank
will
you all
take
for your
this.
help.
Sure.
Thank you.
We'll take this matter under advisement and inform you of our decision, and with that, we are adjourned.
Thank you.